Why? What is the urgency?
That the contract that was terminated, but rig is complete otherwise.
Okay.
Wait, your lordship. In regard to item number 1, my lord, I have filed an additional affidavit yesterday. I don't know how it will work. And with the requisition, your lordship takes up at 2 o'clock.
Okay.
2 o'clock. Meet with the lordship. My lord, I pray for your lordship indulgence, my lord, to allow us for posting of an urgent writ petition for motion. If not convenient, my lord, today or tomorrow, my lord, because it pertains to a tender process, wherein, my lord, I am the prospective bidder, and the authorities have inserted a clause wherein my participation has been somehow, my lord, precluded from the
Tomorrow.
my lord. I'm obliged, my lord.
May I please your lordship, I beg to mention interlocutory application for listing for orders along with the connected WPC
When?
for Monday.
Monday.
Your lordship, I beg to mention a petition for listing, lordship. It's a 2024 matter, lordship, but still it has been listed only twice, lordship.
Why? What is the matter about?
It's to not payment of contractual dues, lordship.
Yeah. When did you file?
Lordship,
When was the notice issued?
18/3/24.
Okay. Okay, Monday.
Item 64,
Chief, I have taken the instruction to make the dismissal and photograph.
Oh, you can, there's no problem with this.
Yes, there is an existing line, my lord, and the road leading up to the plot in question, my lord. There is a 13 feet wide road, my lord. Now, so from the main line till the apartment, 3 pillars have to be erected. So that we can do, my lord. Subject to a direction from this honorable court that the APDCL may seek the assistance of the police authority.
Where is the judgment? As regards the transformer, you have to purchase, have to put the mounting. You have to do all these things by yourself. Normally, heard Mr. B. Nath, the learned counsel, appearing on behalf of the petitioner. Mr. B. Chaudhary appears on behalf of the APDCL. The petitioner herein, which is a herein is a proprietorship firm engaged in the business of real estate construction of flats, public apartments, development and other allied business limited. Full stop. The petitioner constructed a multi-storied building on a plot of land at measuring 1 katha 10 lechas covered by DAG number 1661 new KP Pata number 469 of village Gotanagar under Moza Jalukbari under Guwahati Revenue Circle in the district of Kamrup, Assam, Metro Assam. Full stop. At the time of construction of the said building, full stop, the petitioner constructed the said building by entering into an development agreement with one Sri Sushil Chandra Boisya, who was the owner of the said plot of land. Full stop. At the time of making the construction, at the time of raising construction of the said building, comma, a temporary connection was taken for the purpose of construction of the said building from the respondent APDCL authorities in the name of the landowner Sri Sushil Chandra Boisya. Pursuant to the construction so made, comma, the petitioner applied for a
High tension service connection.
hmm,
A high tension service connection.
a high tension service connection of how much? You have not enclosed anything, Mr. Counsel.
The application form says 74 kilowatt.
With a connected load of what is it?
74 kilowatt.
74 kilowatts.
The application form, my lords, I have given.
Full stop. In that regard, comma, the APDCL authorities had informed the petitioner that there would be a requirement of a construction of a 11 kV line along with installation of 11/0.433 kV, comma, 1 into 100 kVA SS to feed load to the tune of 74 kW. Full stop. The petitioner, and in that regard, provided an estimate of 12,28,814.18 paisa. Full stop. Pursuant to such estimate being provided to the petitioner, comma, the petitioner submitted where that document yesterday you submitted
It's 6 and 6.
a communication to the subdivisional engineer, Jalukbari Electrical Subdivision, who is the respondent number?
Respondent number 3.
Respondent number 3. Respondent number 3. To the effect that the petitioner would take the responsibility of supplying the 11/0.433 kV, comma, 1 into 100 kVA transformer along with requisite materials for construction of the 11 kV line and 1 into 100 kVA transformer at the premises. The petitioner also had submitted an communication to the respondent number 3 that the right of way for construction of the said 11/0.4 kV, 433 kV, comma, 1 into 100 kVA transformer substation would be provided by the petitioner. Pusto.
Along with the service line, my lords.
Along with the service line. Pusto. However, it appears that there has been, however, alleging that there has been a delay on the part of the respondent authorities in providing the connection, the high tension connection. The petitioner has approached this court by filing the present writ petition. Pusto. The writ petition was taken up by this court on 27/6/2025, wherein when Mr. B. Chaudhary, the learned standing counsel of the APDCL, submitted that the petitioner though had submitted the undertaking that he would be providing the transformer as well as the right to way for construction of the 11 kV service line. But the petitioner have not lived up to his undertaking. He further submitted that there are certain local persons who are objecting and preventing the workers of the APDCL from erecting the necessary poles for the said 11 kV line. And as the petitioner has failed to provide the right of way, the APDCL authorities are not in a position to provide the high tension connection. Pusto. The matter, on the basis of the said submission, the matter was directed to be listed before this court on 22/7/2025. Pusto. On the same date, the learned counsel appearing on behalf of the petitioner submitted that the petitioner would provide the transformer as well as the space within the premises of the within the premises wherein the building is constructed for mounting of the transformer, and in respect to the connection and in respect to the objection raised by the APDCL authorities as regards the right of way placed before this court, the judgment of the Supreme Court in the case of Chandu Khamaru versus Nayan Malik and others, reported in 2011, 12 SSC 314. Pusto. This matter, upon being heard, and taking into account that the materials on record do not specifically show as to what right of way the petitioner is required to provide, this court fixed the matter today so that both the councils are in a position to place before this court the materials which would show the material would be in a position to address on the aspect of the right to way. Mr. B. Chaudhary, the learned counsel appearing on behalf of the APDCL authorities, placed before this court a diagram placed before this court a diagram of the proposed line of the DR construction. From the said diagram, the said diagram so placed is kept on record and marked with the letter X. A perusal of the said diagram reveals that there is a public road abutting the public road called the public bylane, a public road which is a bylane of 13 feet width, and the said bylane abuts the land of the petitioner wherein the construction has been made. First, Mr. Beenat, the learned counsel appearing on behalf of the petitioner, further produced certain photographs in respect to the building in question, which is not disputed. And from the said photographs, it appears that the building of the petitioner is abuts with the bylane in question. The said photographs are collectively kept on record and marked with the letter Y. In the backdrop of the above, the question therefore arises as to what directions this court is required to pass in exercise of the jurisdiction under Article 2 to 6 of the Constitution. This court duly takes note of the judgment of the Supreme Court in the case of Chandu Khamaru, Supra, wherein the issue involved was that the appellant in the said proceedings sought for supply of electricity from the distribution licensee but when the distribution licensee did not provide the electricity connection, he filed a writ petition before the Calcutta High Court. The Calcutta High Court, by an order dated 23/9/2004, disposed of the writ petition thereby directing the distribution licensee to effect supply of electricity to the house of the appellant therein within 6 weeks from the date of compliance with all the formalities by the appellant. Pursuant thereto, the distribution licensee gave an electric connection and started supplying electricity to the house of the appellant therein. The private respondents in the said writ proceedings filed a writ appeal. The private respondents in the said proceeding, in the said proceedings before the Supreme Court, filed another writ petition claiming that they were the owners of the land in question and sought for disconnection. The Calcutta High Court, by another order dated 13/2/2006, allowed the said with petition filed by the private respondents and directed the distribution licensee to disconnect the supply of electricity given to the appellant therein for using the land. Full stop. Being agreed, an appeal was preferred before the learned division bench of the Calcutta High Court, and the appeal was dismissed. Resultantly, the matter proceeded to the Supreme Court. The Supreme Court, taking into account the provisions of Section 42, 43, and 67 of the Electricity Act 2003, observed that the appellant therein had a statutory right to apply for and obtain the supply of electricity from the distribution licensee, and the distribution licensee had a corresponding statutory obligation to supply electricity to the appellant. Full stop. The Supreme Court further, taking into account the interstate disputes between the appellant and the respondents numbers 1, 2, and 3 in the said proceedings, observed that the said disputes are to be resolved by way of a before the civil court, and pending resolution of such dispute, the appellant therein could not be denied the electricity. Full stop. Paragraph number 7. Nine, 10, 11, and 12 of the said judgment being relevant are reproduced hereinunder. The above law, the above principles as laid down by the Supreme Court, therefore makes it clear that while the petitioner herein so makes it in the above principles so laid down by the Supreme Court, and applying the same to the facts of the instant case, would show that the petitioner herein is entitled to have an electricity connection as sought for. However, the said right to have an electricity connection is subject to fulfillment of the formalities which the petitioner is required. Full stop. In the instant case, it would be seen that the petitioner is required to provide the transformer as well as the place wherein the transformer is required to be mounted within the land within the premises.
Premises.
Or within the premises will go inside the building.
There is a clear boundary, my lord. If there is a space, then it can go inside.
Within the land wherein the building of the petitioner is been constructed. Full stop. This court also takes note of next the difficulties as expressed by Mr. B. Chaudhary as regards certain disturbances caused by certain local people in the erection of the poles for the purpose of what is the word said from this point to the other point is for the purpose of connection. Huh? What is that word used? For the purpose of
Drawing the service line, my lord, from the
for the purpose of drawing the service line from the main road to the premises of the petitioner. Full stop. This court duly takes note of full stop. It surprises this court as to when the lane, where the road in question, which connects the petitioner's premises to the main road, is a public road. How any local person can interfere in the discharge of the statutory functions by the epidicial. In the opinion of this court, if there is any disturbance caused, the epidicial authorities can very well take the help of the police authorities in that regard. Accordingly, the instant petition stands disposed of with the following observations and directions. Number one, the petitioner herein is entitled to the electricity connection as sought for. The said entitlement is subject to fulfillment of the formalities by the petitioner. That is, and more particularly, providing the transformer as well as the area, as well as the place where the transformer is to be mounted within the land wherein the building has been constructed, whereupon the building has been constructed. The respondent authorities herein are directed to provide the electricity connection, the high tension electricity connection to the petitioner, subject to the petitioner fulfilling his formalities. Full stop. Number three, the respondent authorities further shall this court grants liberty to the respondent authorities to take the help of the police authorities if there is any disturbance caused by the by any third person for fulfilling in the charge of its statutory duties. The police, the officer in charge of Jalubari PS is directed to assist the epidicial authorities in the circumstance any complaint is being filed as regards any disturbance caused. Anything more? What about the polls? He has to pay for the polls.
Yes, that payment he's made.
Has been made, nah?
Yes, madam. At page 43.
He has made. With the above all, so the said formality, the said exercise be completed within 30 days from the date of the petitioner providing the transformer as well as the place for mounting of the transformer within the land wherein the building has been constructed.
Deeply well.
Yes, madam. What are you asking?
Lordship, here in this, after the filing of the writ petition, my lordship, the petitioner, there was an interim prayer in this petition, my lordship, but he was discharged from service, my lordship. In this writ petition, at the time of filing of this writ petition, my lordship, before petition, I had a prayer, along with there was a prayer for not to oust him from service, but in between, my lordship, he was discharged from service. My lordship, I think I have to bring that on the record.
Huh?
In between, he was discharged from service, my lordship. So I think, my lordship, I have to bring that on record. Petitioner, my lordship, he was a casual employee. With regard working in the establishment of member MACT, my lordship, at Silkasar, my lordship. Then there was a regular interview process being done, in which the process was
How permanent can be established? How can the petitioner be done?
my lordship, he was since 2012, my lordship.
So,
In fact, there was a regular selection process for the post of driver, my lord. There was
post
a
of driver.
post for driver by the MACT. Advertisement was issued. The petitioner approached this honorable court, praying for age relaxation. Prior to that, in an earlier round of litigation in 2015, that age relaxation issue was decided up to the division bench. So honorable single judge, my lord, did not pass any interim order. But writ petition was, my lord, interview selection process was over, and recently, my lord, the person has been appointed.
Appointed.
Another person has been appointed in pursuance to a due selection process for the post of driver.
My lordship. Till the filing of this writ petition, my lord, the person was not appointed, and so my prayer was for the consideration, and there was an interim prayer, but in between, my lordship.
Interim period is a very difficult thing to get it felt here. Consider the case of the petitioner for regularization to the post of driver under the establishment of so and so. Now, a person has been already appointed after following due process. Where is the question? No case. Dismiss. Or withdraw, dismiss, which one? Anything you feel like.
My lordship, then, my lordship, I pray for an order.
For what?
If I withdraw,
Okay. Shall- Heard Miss So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. H.K. Das appears on behalf of the respondent numbers 1, 2, and 3.
No, my lord, 3,
1,
seven.
respondent numbers
6 and 7.
2, 3.
Yes.
Respondent number 3,
6 and 7.
6, and 7. Full stop. Miss Yudas appears on behalf of the respondent number 1 and 5. And Mr. Asolia appears for the respondent number 4. 4 only. 4 only.
The order of appointment.
4 only. Full stop. The petitioner herein, who was working as a driver,
driver.
in the capacity of a driver in the establishment of the learned member motor accidents claims tribunal, Silchar, has filed the instant writ petition seeking regularization to the post wherein the petitioner have been discharging his functions for the last 12 years. 12 years, 13 years, last 13 years. Full stop. It has been brought to the attention of this court by Mr. H.K. Das, the learned standing counsel of the Guwahati High Court, that in pursuance to a proper selection process initiated, a person has been duly selected and he have been appointed against a vacant post. Full stop. Taking into account that a person has been duly selected and appointed to the vacant post, the question of regularization of the petitioner against the said post does not arise. Full stop. It has also been brought. Considering the said, this court does not find this to be a fit case for exercising the writ jurisdiction in the matter for which the writ petition stands dismissed.
Much obliged.
Namadibo, Litat Madibo. Oh, nobody is appearing. All these people are scared of the panchayat, and who is for panchayat? What is he asking for? Non-payment of bills. Huh? Why there is earlier another writ petition? Who is for the PNRC? Pustap. None appears on behalf of the petitioner when the matter is called. Pustap. Considering the above, the matter stands adjourned. Pustap. In the meantime, Pustap, this court directs the registry to have a registry, directs the registry. Register, who will be in charge of register bench, filing? Huh? Direct the register, deputy register key, filing. Directs the deputy register filing to peruse the enclosures attached and peruse the annexures enclosed to the instant writ petition and verify as to whether the same appear as to whether the same in the meantime, this court directs the deputy register filing. No, in the first, none appears and lists the matter after 3 weeks. None appears on behalf of the petitioner. Full stop. So this court have perused the enclosures to the writ petition, and the same do not appear to be legible. The deputy register filing is directed to look into the same, and thereupon, after the learned counsel appearing on behalf of the petitioner provides legible copies of the enclosures, the matter be listed before this court. Yes, Mr. Sahu. What is this?
Election of the keyboard authorities or sanction of the key subsidy.
Huh?
Keyboard authorities are not functioning the keyboard key subsidies to the listener.
What do you want?
So they may allow to
Read in the matter authority to release the tea subsidy on tea plantation in accordance with the scheme, and or to initiate proceedings according to the policy of the central government under the tea development area. What?
actually the central government is framed a policy for providing for developing the tea industry, tea plantation and replantation of the tea garden.
Certain subsidy. Then
After we have applied by through online, they have made inspection. And Thereafter, they are keeping silent without any procedure, nothing.
Worship, I take instructions.
Issue notice. Is the case for issuance of notice or dismissal right away? The instruction is with notice. Otherwise, we dismiss it. Issue notice making it returnable on. You have to take instruction from where? Ministry of Commerce, from the T board. You are paying for the T board?
Worship, it's a subsidy.
Okay. So you pay for 1 to 6?
Yes.
Okay, issue notice making it returnable on 22nd of September 2025. Mr. R.K. Dev Chaudhary, the Deputy Solicitor General of India, appears on behalf of all the respondents and accepts notice. Extra copies of the writ petition be served upon him during the course of the day. The case of the petitioner herein is that where is that subsidy scheme? Where is that?
Annexure,
Page 18.
page 18.
It is the case of the petitioner that the keyboard that the government of India, that is the case of the petitioner, that the government of India has conveyed its approval for the T-board scheme, wherein certain subsidies are provided in respect to plantation of tea plants. Full stop. The petitioner herein applied for the said subsidy in the online mode, and the concerned respondent authorities have inspected the same. However, the respondent authorities are not, have not provided the subsidy for which the petitioner has approached this court. The respondents are directed to bring on record their stand by filing their affidavit on or before 15th of September 2025. Full stop. The petitioner, if so advised, would be at liberty to file their reply on or before the next date.
Number 5, the same.
What?
Number 5.
Five
It's the
again
period
will.
is different.
Huh?
It is the same claim, Worship, the period is different. One is from
This
January,
is for which period?
this is for July to,
No, this is not July, this is for Napuk tea estate, that is another tea estate, Sarjan tea estate,
I'm sorry.
same issue.
These are all under APJ. Who has come? This is for which tea state?
This is for Napuk, item 3, 4 is Napuk C and 5 is Harjan tea estate. Harjan tea estate.
Kharjan.
My lord, in this case, another item number 27, same issue for the same party. So I have to file a rejoinder for that.
No rejoinder. If he has, you have
Another
filed some reply there.
Yes.
So we can take up for disposal 3, 4 together. And he has not filed his rejoinder in spite of time.
27, item 27.
post
So-
appears.
Don't come up with all these things here. Your 27 will be taken as the last item of the day. And if you don't appear, we'll dismiss for default. So you wait because of what you are saying. Otherwise, 27 would have reached earlier. Now
No,
we'll
no,
take
madam,
it at
no.
4:45.
Sorry, sir.
Yes. The last item, 27, last item of the day. What are you challenging?
Order passed in Lok Adalat.
Then?
Order passed in Lok Adalat, madam.
Why are you challenging?
Well, because we have not signed. Our advocate has signed the settlement agreement.
Huh?
In the settlement proceeding, madam, our representative were not present. Only our counsel was present. He signed on behalf of the company, my lord, for settlement. It is at page number 29, my lord.
Matter settled at rupees 4,55,000, 7,000, so and so, the amount shall be paid by the appellant company within a period of 2 months from today. Failing which the said amount shall carry 6% per annum. It happened where?
Happened well on 14/9/2024.
So you did not authorize
Yes, my lord,
your advocate.
to settle.
Okay, where is your communication to the advocate in that regard?
In that regard, my lord, we have mentioned that there is no communication with that.
No. Where is your communication to that? Communication to that the advocate that you have done it?
Yes, my lord, yes. It is at page number 32, my lord, and 32.
Last Monichori, with reference to the area, we'd like to inform you that we had appointed you to defend our company in the so and so before the Honorable Iman. But to our utter surprise, it is now noticed that you have entered into a settlement of the matter in the local adalat before the Honorable State Consumer Judicial Forum without any kind of prior written approval from a company. Further, you have not intimated such development to a company and kept our firm. Either during filing of the mixed case on behalf of a company, you have neither pleaded the same nor intimated a company about the same. Now, what action have been taken against this advocate?
My lord, we have also applied to the bar council. This is page number 33, my lord.
Page,
Page 30, next page, my lord, page 33.
Bar Council, Adgaon. Bar Council's office is in Adgaon.
My lord.
Where is it?
It is in that water.
Then this must not have gone. Whether the Bar Council will receive this document? Huh?
Wrongly written, my lord. I've just taken it.
Bar Council address 2nd floor High Court building.
Yes.
Adgaon.
Now it's wrongly typed.
Where is the receipt of this document?
Document is not with.
Full stop. List this matter again. Next week or the date video. On 28/7/2025, on which date the learned counsel appearing on behalf of the petitioner shall produce any acknowledgement from the Bar Council of Assam. Assam. Where is the Bar Council of Assam?
These are officially sent.
Acknowledgement of the Bar Council of Assam in respect to the communication enclosed as Annexure H to the writ petition. Produce that.
Okay. Briefly, please.
What is this?
My lord, the petitioner is the agent of the private shop.
Suspending the
That's
fair
what it-
price shop.
Page 14.
Show cause notice.
Page 14 is the my lord order. Order this order passed on 30
Peruse the inspection report of so and so, taking all the facts in the inquiry is placed on the suspension. Then you are being given a show cause. Then you have replied to the show cause.
Yes.
Then what happened? Okay, cancel the license. Cancel the license. What is there?
My lord,
Decision has to be taken.
Within 90 days. 90 days. Na?
and already expired like this. Election order was suspension order passed on 30/10/2024.
Hmm.
Now today is in the month of July.
Hmm.
90 days, more than 90 days, they kept it under suspension.
Hmm.
Order 15/1
Hmm.
to public distribution order 1982.
Hello.
And no other.
Okay, we issue a short notice. In the meantime, cancel it. While I issue notice, it shall not be a bar to cancel.
Just
No, I will put it, it shall not be a bar to cancel
My lord,
it. To take a decision on the show cause notice.
only problem is. my
Your
lord,
thing is on rule 15.
Yes, it cannot.
Clause
exist.
15 says that it has to be within 30, 90 days. And if not, it has to be reinstated. That's all.
Automatically cancel.
Without giving any opportunity to the licensee of stating his case. That is one of show cause. So show cause has been issued, my lord, within 2 months, my lord. So.
No, you can't keep this under suspension because you see, the fair price shops are specifically given for the people at large. Now, it is therefore you are to complete this entire exercise within 90 days or something. You cannot have it for all times to time. You have to take a decision. Your co-district commissioner Lahori Ghat has
There is
some
a decision.
problems. Issue notice.
There is a decision of this noble court, my lord, already was done. If within 90 days they will not comply to,
Where is
then
that?
automatically gone.
Where? Then.
I will vote it.
Then,
Then next week I will vote it. my lord. That order, my lord.
issue notice making it returnable on 30, 1 week, 30/7/2025. Miss you, the learned, you are additional
Additional.
senior government advocates accepts notice
All right.
on
my lord.
behalf of the
7.
respondent numbers
7.
1, 2, 6, 7. Why you are making the other people a party? What is this cooperative society?
It may be delayed.
Your case is specifically on the question of suspension. Are you not?
Sir,
So why you are making, you are only to make the district commissioner or the director, you don't even require the director of civil supplies.
my lord, I will allow.
Not no, you, okay, issues accepts notice. Can you accept on behalf of the cooperative society? No, that is another person. And who is the cooperative society? You are there.
Yes, sir, yes, sir. 7.
I can appear for 7.
Okay. Miss-
It may be deleted.
I won't delete. It. Accepts notice on behalf of Miss MD Bora appears on behalf of the respondent number 7. Huh? You thus appears for respondent number 1 to 6 and appears for respondent number 7. Full stop. Extra copies of the and accepts notice. Full stop. Extra copies of the petition be served upon them during the course of the day. Full stop. This court, taking into account the present dispute, is not inclined to issue notice upon the respondent number 8. Full stop. The case of the petitioner, in brief, is that the petitioner is engaged, has been issued a fair price license, fair price shop license, fair price license to carry out sub wholesale / retail business of notified articles at village Tengaguri PS Lahori Ghat. Full stop. On 30/10/2024, the co-district commissioner Lahori Ghat that is the respondent number 4 herein issued an order thereby suspending the FPS ID number 130400100380 on the basis of an inspection report submitted by the inspector FPD NCA Lahori Ghat. Pursuant thereto, on 9/12/2024, a show cause notice was issued as to why his license should not, why the petitioner's license should not be cancelled for misappropriation of 4.45 quintal rice and contravening the provisions of section 10(1) of the TPDS bracket control and existing SOP relating to distribution of NFSA oblique 13 rice issued by the government of Assam. The petitioner submitted a reply
But no hearing has been taken to this.
on 12/12/2024 and requested that the suspension be removed. First off, it is the specific case of the petitioner that more than 9 months have expired pursuant to the suspension, and 7 months have expired pursuant more and 7 months. 8 months have expired, and 9 or 10 months. Or if 7 months have expired, 8 months have expired. Pursuant to the submission of the show cause reply, but the respondent authorities have kept the petitioner's fair price shop under suspension. Referring to clause 15 of the Assam Public Distribution of Articles Order 1982, Mr. J. Ahmed, the learned counsel appearing on behalf of the petitioner, submitted that the suspension of a license, fair price license, cannot extend beyond 90 days. And as such, the said suspension order is required to be interfered with. First, Ms. So-and-so appearing on behalf of the learned counsels appearing on behalf of the respondents are directed to obtain instructions as regards instructions in respect to the grievances of the petitioner and place this court before this court positively on the next date so fixed. Huh? The registry shall show the name of Miss M. Deborah, SC, Operation Department in the cost list.
Sorry, guys.
Yes, what is this? Should not be issued by setting aside the corrigendum dated so-and-so, NIT dated so-and-so issued, and should not be issued by directing the suit to settle so-and-so in favor of the petition. What is your case? Out of station. Would he likely to come back in the month of October? It's the matter of the 2 weeks. Yes, what is this?
Yes, Mr. Pertains to non-payment of contractual amount of
Non-payment, how much?
10 lakhs.
Huh?
10 lakhs.
Only.
Work
10
completed
lakhs.
in the year 2023.
Huh? Are you sure?
Yes.
This is some
Completion
NIT.
Yes. Completion certificate is.
No. To release the fund to the petitioner who have completed the tendered work as per the NIT. Okay. How much you asking? 10 lakhs.
10 lakhs.
How much you have received?
No, Lord.
Huh?
Yielded notice. Completed in 16/10/2023.
2000?
23.
Okay. I hope issue notice making it returnable on 24th, 17th of September 2025. Ms. Udas appears on behalf of the respondent numbers 1,
3,
3,
5, and 6.
5, and 6. Who is to pay?
Madam, municipal administration, madam. Lakshmipur,
Yes,
sorry.
A
Lakshmipur.
municipal board or
Board.
municipal? Board. So these are only
Madam.
other part. And Mr. A. Solia appears on behalf of the respondent number 2 and 4. Full stop. The petitioner herein, full stop, and accepts notice, extra copies of the writ petition be served upon the said councils during the course of the day. As regards the respondent number 7 and 8, steps be taken by way of registered as well as usual. In addition to that, the learned counsel appearing on behalf of the petitioner also expresses urgency in the matter, for which liberty is given to the petitioner to take steps by the way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The case of the petitioner herein is that the petitioner completed the work, contractual work, in respect to work order number LMB-36/2020/12, dated 15/12/2021.
30,
For-
01, 20,
Huh?
30, 01, 21.
What 30? What 30? Your representation is at page annexure 13,
30,
13,
Annexure to page 19, madam.
page number 9.
page.
Annexure 2.
Annexure to
Annexure to
page-
page number 19.
Which work?
Second.
Construction of pavel. Huh? No, I'm referring to the work order. This is a notice inviting tender.
Work order is 20.
Yes, I'm right.
Page
Yes.
number
Page
23.
23.
Yes.
That is what I am referring to. Mr. Counsel. Kile. The petitioner is aggrieved, huh? The work in respect to work order number LMB 36/2020/12 dated 15/12/2021 in respect to construction of paver block station at Lakhipur public bus station stand at Halua Para, Ward number 4 under 5th ASFC for the year 2019-20 for second part under Lakhipur Municipal Board in the district of Kualpara, Assam. Full stop. Even after completion of the said work and handing over, comma, to the satisfaction of the respondent number 7 and 8, no? 7 and 8, comma, the payment of rupees 10 lakhs to which the petitioner is entitled to have not been paid by the said respondent number 7 and 8. It is under such circumstances the petitioner has approached this court seeking an appropriate redirection in order. Full stop. The respondent number 7 and 8 are directed to bring on record their stand by filing the affidavit as to whether the petitioner is entitled to the amount as claimed. Full stop. On or before the next.
All right.
Yes.
Well, it's not a wrong premise that there are co-partners, my lord, my candidature is sought to be rejected. Now, if a lordship would kindly come to the impugn order, my lord, impugn mail at page 52.
Yes.
If your lordship would kindly come to that after dear sir,
Ah.
Two, this is to inform you that during field verification of credentials, you failed to produce original land document for verification by officer. Land document produced by you were at variance with the document submitted. Information given in the application as stated below. The lease deed dated was executed between the selected applicant Jackie Rabha and two owners, namely Barindra Puttradhar and Bakanta Sutradhar, for 1 bigha of total 2 bigha and 13 lessons of land covered by that number 40 of Pata number 13. In accordance with Jamabandi, there were third co-owner, late Kanuram Puttradhar, who expired prior to execution of the lease deed on 16/11/21. Upon his death, late
No,
Kanuram.
Mr. Chaudhary, why
Yes.
there are two reference to two lease deeds?
Yes.
The first
What
one
had
is
happened,
16/10/2023.
Yes. In that is the lease deed which were given. That was executed by these two brothers, Barindra and Bakanta.
Ah.
And Milord, yes, it is a fact that in that Tag Milord, there are other land also. That is to the third brother. He has died and his wife is also there presently. But in respect of the 1 bigha, there is nothing, Milord. They have confused with the expression co-owner and co-pattata. That is the whole thing. Now, this will clarify the position, Milord. There is only one list. Yes,
There's only,
one list.
there's
Milord
not
will-
two leads.
No, no.
Oh, there's
saying the
something
date
must be a wrong thing.
16/11/21 is the date of death of the third part. That's what it is.
Where's the lease deed?
Yes. Lease deed is that page number 6, annexer 6, page 37. Milord.
Lease deed.
Kindly see, this is by Barindra Puttradhar and Bakanta Sutradhar and Jackie Rabha. In that Dag Milord, there are several pattas. We are concerned with Dag number 90, patta number 13.
Hmm.
Now, at page number 44, if your lordship would kindly come, is the Jamabandi. Barindra, Bakanta Sutradhar, Barindra Sutradhar and Bornali Puttradhar. Bornali,
Page number?
page number 44. Sir.
54.
Kindly see, new Dag number 13, patta number and Dag number 90.
Hmm.
Now, 2 bigha, 13 lessons of land.
Hmm.
Now, kindly see, my lord, Bakanta Sutradhar and Barindra Sutradhar are the lesser of the petition.
Hmm.
Now, this Bornali Sutradhar is the sister-in-law. Now, as far as Bornali Sutradhar is concerned, my lord, if your lordship would kindly come to page 50, that will make the yes, lordship, may kindly have a look at page 45 also. Sir.
Hmm.
This is an affidavit by Bornali Puttradhar. Page 45. Para 2, that my deceased husband, Kanuram Puttradhar, along with Bakanta Puttradhar and Barindra Puttradhar, both are sons of late Saurya Puttradhar, are co-pattadars of a total plot of land measuring 2 bigha 13 lessons covered by Dag number 90, patta number 13 in revenue village number so and so. That I have been possessing and enjoying a part of the land measuring 3 katha 11 lessons as my share as per the mutual family partition out of the total plot of land measuring 2 bigha 13 lesser about 3 years ago, and now intend to partition my share of the plot of land in my name before the concerned authority, and in this no objection will be raised from any quarter. That the co-pattata, namely Barindra Puttradhar.
Where is the clause on which he has come?
Yes, because that clause is quoted in the order itself.
No, no, where is the clause in the, where is the book? Why haven't you enclosed that?
No, I'm giving.
Don't you think that this should have been a part of the
Yes,
record?
yes.
Then file an additional affidavit. List this matter. When do you want it?
Yeah.
Is the matter on Friday? In the meantime, I'll
Can it be
additional.
on Monday, madam? Can it be on Monday?
No, let it be on Friday.
I'll not be in station.
He has cancelled only. He will be now, you are put in category 3. Category 3, it's okay. Have you taken any decision on this? No, no.
It's not any.
Let it be on by Monday. Because without that document, in fact, you couldn't have gone ahead. And the applicable one, don't give me an owned one. Remember?
It's.
Ah.
That question I also posed. There's five.
Because there is every year they come up with another one. Because I remember taking up a matter of Miss N. Sekia. She filed the entire case on 2007 guidelines, and she was doing a matter of 2014. And 14 by 14, another two guidelines have already had happened. List the matter on Monday, on which day the petitioner is given the liberty to file an additional affidavit, bringing on record the guidelines, the brochure containing the terms and conditions for allotment of, what is that?
Retail outlet.
Retail outlet by IOCL
Oil marketing companies. It's a common retail outlet dealership process.
of
All the oil marketing companies.
They call it OMC, na?
OMC. Oil.
what do you think? Retail
marketing
brochure for allotment of retail outlet by the respondent company. Respondent company. What is this non-payment?
Non-payment of running discourse.
Then why you are not paying?
We'll file affidavit.
What is your stand?
Actually, it is running bill and it
You have
must,
not filed affidavit.
No, they have not.
after filing Vakaratnam, it has come up for the first time after 7.
No.
We have been interested in 2018. Thereafter, it is come up for the first time. This year. 18, I have been engaged in the case.
2017 matter. What is wrong? We are paying for whom?
All the respondents.
Okay, verify and make the payment, whatever is entitled to.
So which time for filing?
Verify and pay within 6 months. If he is entitled to, the order will be specific. In Dorothy is into this. Dorothy is the order. Where his submission is that as regards the petitioner's entitlement, there will be a question of verification which is to be carried out. And after verification, can be discerned as to whether there is any amount the petitioner is entitled to. That's what Dorothy is into order. Verify within 6 months. And certified copy is to be given to whom?
Respondent number 2.
Respondent number 2. Huh? Post. 6 months. Oh, I can't take it up. Please the matter before any other bench. What is this?
In WPC 1
Deenath Swain submits the incident has become infructuous in view of the fact that the breach upon which the petitioner claimed to have a right to collect is observed petitioner is dismissed. The other one is also same. None appears. Last time also they did not appear. None appears on behalf of the petitioner on call. Mr. Deenath appears on behalf of the state of Assam, on behalf of the respondent numbers. The learned senior government advocate appears on behalf of the state respondents.
3, 4, 5, 6, and 7.
Huh?
3 to 7.
3 to 7.
7.
And Miss M. Deborah appears on behalf of all are same respondents.
Transport department and then deputy commissioner.
I'm not on that. So appears on behalf of Miss M. Deborah appears on behalf of the transport department, and Mr. Deenath appears on behalf of all other state respondents. Full stop. In both the proceeding and duta order. Full stop. It is it is relevant to take note of that when the instant writ petition was listed on 14/7/2025, this court, taking into account that the petitioner was not represented, did not pass any order for the ends of justice, thereby granting the petitioner a further chance. Full stop. This court have also taken note of the submission so made by Mr. D. Nath on the earlier occasion to the effect that the writ petitions have become infructuous in view of the fact that the bridge upon which the petitioners claim a right to collect toll is no longer usable and operational. Full stop. Taking into account the above, it appears, therefore, that the petitioner is not interested in the instant proceeding for which the instant writ petition stands dismissed for non-prosecution. Duit kita deh, beleg-beleg. Here.
31/7/2025, my lord, fixed with a series of water resource matters, my lord. Maybe this matter will be fixed with those similar matter, my lord, along with WPC 2303 of 2025. On 31st.
We're paying for water resource. Huh? No, none appears. What?
Mr. Dasi is on lordship in some other court.
None appears on behalf of the Water Resource Department when the matter is called. Considering that, first of this court further takes note of that notice was issued by this court in the year 2023 when the matter on 24/2/2023, and in respect to seeking instructions as to whether the petitioner is entitled to an amount of rupees 4,18,407. Considering the above, this court fixes this matter again on 1st of September 2025. It is observed that if the Water Resource Department is not represented and no instruction shall is produced, this court would proceed with the disposal of the writ petition on the basis of the materials already available on record. What?
I'm appearing for water.
Okay, very good. Tell me. Instructions. I'm asking you instructions. Whether the petitioner is entitled to the amount or not. Don't go as per the series.
It now entitled to rupees 4,18,407 as per my instruction, lordship.
Then why you're not paying?
Lordship, that some money has to come from central government, Ministry of Jal Shakti, lordship.
Then there is a judgment of Justice Suman Shyam on this aspect, wherein there is a specific direction to what steps are required to be done.
Yes, lordship.
Where is the judgment? Mr. Jain, don't appear in the court without knowing anything. It appears the counsel appearing on behalf of the petitioner is not aware about the matter for which the matter stands adjourned to be listed. Adjourned Sinadai. Adjourned Sinadai. It won't come up.
I have the judgment.
Then where is it?
My lord, this time.
When a matter has come up for admission, that means, yeah, do you want this court to issue a rule? Okay, we'll issue a rule.
Similar matters are fixed on.
I'm not concerned with the similar matters fixed or not fixed. When there is an admission to that amount, the stand is that some amount is to be paid by the central government. There is already a direction passed by this court in a similar matter. Why on earth you don't have that order?
What is in the next statement?
Sign that. It will come after 10 years.
No,
10 years.
I have the order, but
10 years. Laho. The counsel, Mr. D.K. Jain, is not prepared with the matter for which the matter stands adjourned to be listed after 4 weeks.
Regarding the liabilities, pending before the authorities. Here, I have received the instruction what happened, by mistake, the documents, bills and vouchers were sent to the State Election Commission, then they have sent to ANRD, then again it has gone to AG. Now, after this or passing of this
Are
order,
all
my
these
lord.
cases as regards non-payment of dues?
Panchayat elections,
Huh?
payment of dues for Panchayat election 2018.
Yes, now, my lord, it was not traced out, my lord. Now, my lord, it's pending before the AG office, my lord, the original bills and vouchers, except, my lord, two, 15 and 16, my lord, item number 15 and 16. These vouchers could not be traced out till now, but hopefully, my lord, we'll get that, my lord. I have received the instruction, my lord, and I pray for, my lord, 2 weeks time so that,
Why?
my lord, to get the, my lord, original vouchers, it was sent, my lord, mistakenly, it was sent to AG, to the ACB.
Are you
Yes,
denying that whether he's entitled to the amount or
No.
not?
Just
Verify. If he's entitled, pay. Don't, and not entitled, don't pay.
what it passes, my lord.
Let's sort out. Pay, make the verification, complete the entire exercise within 6 months.
So,
No, no, you will come up with an affidavit stating that he is entitled to.
if-
No, I am not. I am
Verified
not asking you, are you going to come up with an affidavit that the petitioner is entitled to? Because I have asked you when I issued notice in this matter on 22/1/2024. Does it take such a long time?
Chairman, but here, understand was that we have already sent to the Malad PNRD department and that is pending there. Now, Malad last of it.
No, we are not concerned with the PNRD department. Who had issued the notice? Who had issued the work order?
Commissioner,
That-
during the period of Malad that in Panchayat.
Now tell me, can the deputy commissioner issue a work order without a proper sanction?
Panchayat election, Malad,
The deputy commissioner cannot.
Right.
If the deputy commissioner cannot issue a work order without a sanction, and if he has done so without a sanction, then that deputy commissioner has to be taken to task. But you can't deprive a person who is otherwise who has serviced you, who has given you all the facilities when it is needed, and then say, "Oh, we will pay when we feel like." Mr. Todi, Dr. Todi, show me where is your work order. Supply the following materials to the material cell area, Karishma, by the Chief Executive Officer, Nalbari Jilla Parishad. No, this is not by the Deputy Commissioner. No, your work order here in this item
Item.
is by this item by Karishma. Karishma Enterprise. Karishma Enterprise is by the Chief Executive Officer, Nalbari Jilla Parishad.
Under the office of the Deputy Commissioner Lalbari.
Where?
The top
Office of the Deputy Commissioner, but he has done it.
Yes, Lordship, then we have submitted our bills.
And this is being issued even without fixing a rate. What type of these things are there? Huh? Is this state money is being wasted like this? Why departmental action has not been taken against the chief executive officer for not fixing a rate? Because he submits his bill in 2019 and claims this amount. Meaning me what? Whenever he feel like he will do it at his own rate.
Mal, you can put any amount, Mal.
Huh?
You can give any amount, put any amount. If it is not fixed.
No rate fix. How is it possible? Here also same.
Mal.
Cup. What is this item number 16? Cup for empty cigarette tin for setting the ink edible bottle. Sufficient quantity of ribbon or tape for securing ballot box, big size. Cotton tape materials received. And he fixes the price.
So we need to verify malad the vouchers malad because
No, vouchers, okay. Why these people have issued without fixing a rate? First, no tender, okay, immediate you want to do it very well. But you have to fix a rate. This Chief Executive Officer, Nalbai Jila Parishad would be under whose department? PNRD. Madam, I intend to pass an order upon the Commissioner and Secretary PNRD to make an inquiry as to whether these type of work orders are permissible without fixing a rate. Because this is a very serious aspect.
crore is malad.
How do you place an order like this?
Rates is concerned, there must be some internal already fixed rates
How do you know?
because part payments were made based on this.
Part payment also has been made.
In some of the cases, part payments were made. It's not that the entire bill amount is pending. And in all the bills, the rates which have been given, there must be some internal because without that, it's obviously not possible to submit the bills. And it has been verified by the officer also.
No, there is no mention also what rate
Yes, I understand. So far in the
or
work
mention
order is
to
not
on
there.
what there is already an admitted rate, fixed rate. How is it possible?
19 malad now 524.
What do you say? PNRD.
Item number 20.
It's okay.
Lordship
But the
is on-
question is how on earth do you issue such type of work orders without fixing a rate? This will be under the PNRD department. PNRD is headed by
Commissioner malad.
Commissioner and Secretary. No, whatever may be, who heads the PNRD? Madam, I'm not concerned with whoever it is. I'm asking who heads the PNRD? You are a PNRD council, you don't know who heads the PNRD? Commissioner or Commissioner and Secretary? Commissioner or Commissioner and Secretary? Commissioner. Okay. Full stop. The instant batch of writ petitions relates to non-payment of the dues to the petitioners. For supply of materials during the panchayat election held in the year 2018. 18, na? Full stop. Ms. Yudas, the learned additional senior government advocate, submits that those vouchers which have been collected have been sent to the PNRD department.
State Election Commission. Commissioner Nadi has sent to AG office. Now it is lying in.
Submits that the vouchers in question have been furnished by the State Election Commission to the
Commissioner PNRD.
Commissioner PNRD. And the Commissioner PNRD thereupon has forwarded the same to the Office of the Accountant General
Right.
for the purpose of necessary verification and disbursal. Be that as it may, this court finds it very pertinent to take note of the work orders which have been issued to each of the petitioners mentions about certain quantities to be supplied, quantity of materials to be supplied. But there is no rate fix at which these quantity of materials are required to be supplied. The materials on record further show that after a period of almost 1 year, that is in the year 2019, vouchers were the bills in respect to the supply were submitted by the petitioners claiming various amounts. And on the basis of and on account of non-payment of the said amount, comma, the instant writ petitions have been filed in the year 2024 and 25, respectively. This court finds it very pertinent to observe that the manner in which the work orders have been issued to the petitioners by the Chief Executive Officer of the Jila Parishads surprises this court in as much as supply orders have been issued to the petitioners for quantities without fixing the rate. First, this court therefore would direct the commissioner, PNRD, under whom the chief executive officers, under whose department the chief executive officers of the Jila Parishads function, as to whether to put it on affidavit as to whether such a practice is permissible of issuance of work orders without fixing the price, in as much as the same may have a catastrophic effect on the economy of the state. First, list this matter again on 1st of August 2025. The affidavit be filed by the Commissioner PNRD on or before that date. List accordingly. Because this is a very serious bringing the finance, because these things needs to work properly. It's vouchers.
Bills were not submitted after 1 year or after 2-3 months only.
You submitted in 2019.
Lordship work order is of November 18 and I submitted in March 19.
And then why did you wait?
Because there were Lordship already communication by the Deputy Commissioner.
There's no communications out here.
And enclosed Lordship my letters, which they have also provided copy.
Don't worry, these petitions will be dismissed on limitation. I will pass orders to the effect. But first, let me correct it with these people. How on earth they are issuing this type of work orders? You file your affidavit. a copy of this order be furnished to Ms. So-and-so representing the PNRD for decompliance.
We have received instruction, Lordship.
Oh, yes. Got it?
Lordship. Serial number 1 belongs to the retribution. What is surprising, Lordship, the prayer is in respect of 14 lakhs. Now the instruction says that it is 16 lakhs. Serial number 1 allowed in Chaudhary.
Madam, why you have not made the chief executive officer, chief engineer party? You see, you are aware of Tasminali or what that, Kamsarali. When an officer gives a detail as regards entitlement, it would be only taken into account when the chief engineer vouches that amount, not by the executive engineer. Because an executive engineer's statement cannot under any circumstances be said that there is an admission of the liability by the department. Should have made. Anyways, Lahore. Heard Ms. B. Chaudhary, the learned counsel, appearing on behalf of the petitioner. Mr. R. Bora appears on behalf of the
PhD department.
PHA division, PHA department. The petitioner herein have the petitioner have filed the instant with petition being aggrieved by the non-payment of an amount of rupees 14,70,712 by the office of the respondent number 2, in spite of the fact that the petitioner completed the work which was issued, in spite of the fact that the petitioner completed the work in question. The matter was listed before this court on 3/6/2024. Huh? This matter came up before that day, na? For me.
No, Lordship, that is item number 29. That is item number 29, which your Lordship directed.
This is another matter.
Yes.
On 3/6/2024, the counsel appearing on behalf of the PNRD department sought for time for filing their affidavit in opposition. Today, Mr. Arpora, appearing on behalf of the PHE department, submits that the petitioner in this case, the petitioner that as regards the petitioner, as per the certification given by the executive engineer PHE, Hosai division, the petitioner is entitled to an amount of rupees 16,62,183. And the said payment could not be made on account of non-receipt of funds. This court is of the opinion that the said aspect be brought on record by filing an affidavit by the chief engineer. Which one? Chief engineer who?
PhD department.
PhD, only one chief engineer is there.
Yes.
By the chief engineer PhD department, as to whether the amount of rupees 16,62,183 is the amount to which the petitioner is entitled to. First, list this matter again on 8th of August 2025, the affidavit be filed by the chief engineer PhD department on or before 6th of August 2025.
petitioner lordship had fixed on 4A. The matter pertains to the fuel and power purchase adjustment, your lord. There the petitioner was claiming whether it will be.
Oh, that's our church.
Yes, your lord.
That day when I was taking up, where you raised the issue of non-maintainable.
Yes,
that
now
the
in
same
fact, yes, same man, that matter.
When have I fixed that
That
matter?
matter is fixed on 4th of August.
4th of August. You have it along with that?
Yes, in fact, the rules that they have, I'm just praising your lordship.
Hmm.
The second rules which they have enclosed, the draft rules, they were not even in force. They came in force.
There is nothing to, therefore in my order, I didn't refer to that.
Yes,
That is why here only the issue is as regards the interpretation to clause 5.5
5.5.
as to whether that period, because their submission, if I remember correctly, their submission is that it has to be quarter, meaning thereby January, February, March, April to June, July to September, October to December. So they say. So therefore, their saying is that you cannot have it retrospectively for another period or in between the quarters.
Yes,
This is their submission.
yes, sir.
I've asked you to file an affidavit
Yes,
in
sir.
that regard. We'll have it on 4th.
Very good.
This the instant matter, instant proceeding petition along with WPC number 720/2024 on 4th of August.
4th of August.
So I want.
Huh?
I want.
Your name is not shown.
So in this order, in today's order.
Orders, I've not put anybody's name. You put your name up there. My orders always reflect on the top who are the representatives.
But I'm applying for a number of form.
I've not said who the petitioner has represented by.
No,
Mr. Gogoi, there. Same type, same order.
That's the same inspector.
Here, how much he is entitled to?
109,706. 10 lakhs.
Sudhan Roy, a amount to is
Second.
entitled to yet petitioner. How much he has claimed?
14 lakhs.
Yeah.
70,712.
Here also same amount. Were you claiming the same amount in both petitions?
That was my instruction, lord.
ইয়াত এইটো আগৰ অৰ্ডাৰটোতে লিখিব 14 lakhs claim কৰি 14 lakhs 70,712. However, the executive engineer কোৱা মতে is 10 lakhs 97,063. One affidavit এখন file কৰিলো, same date. Fixed along with that. This is the matter along with the earlier matters into order.
89 lordship, this matter is.
Oh, that matter?
Yes, lordship.
What is that?
Here, lordship,
Name?
Jayanta Bhagavat.
Jayanta Bhagavat. Here, his name is not there.
Oh, then?
But as per my instruction, lordship, which I have received, it says that 3,33,077 rupees was the outstanding amount, out of which on 16/3/2016, 49,387 rupees was released, and now the outstanding amount is 2,83,220, and petitioner has claimed.
সেইটো তেখেতক মাতি দিওঁ।
May I place this instruction, lordship?
আগৰখিনি এনেকে থাকিব, but the claim out here is 2,89,878.
Yes.
Also লিখিব, on 16/7/2025, the instant petition was listed, wherein when Mr. Arbora, appearing on behalf of the PHA department, sought a final opportunity to obtain instruction as to how much the petitioner is actually entitled to. Mr. Arbora, during the course of the hearing today, submitted that as per the verification carried out,
I have just highlighted it. Para number 16, lordship.
verification carried out, comma, the total bill of the petitioner for the work completed was rupees 3,33,077. And certain payments were made to the petitioner. And after making payment, the department is further is liable to pay an amount of rupees 2,83,220 and not rupees 2,89,878 as claimed. Full stop. This court directs the chief engineer, each department, to make the necessary verification and file an affidavit as regards the entitlement. List the matter again about the jete issue. What no 8 niki? I fix it on 8.
But you directed to file affidavit before 6/8.
Huh? 8 to file an affidavit. And list the matter on 8/8/2025. In the meantime, the said affidavit be filed. Huh? The instructions are placed. Should I keep it?
Okay.
It's kept on record. Now you have it. It will help you in preparing that. You want this one?
No, Lordship, I have. Always.
It will hit to case of bird. Yes.
Sir, instruction, malad, as per our instruction, malad, remaining malad outstanding amount is 60,67,608. They are claiming probably 52 lakhs.
No, forget about that. Direct you, only pay this amount. Any additional amount if you want, file a civil suit. Heard, Mr. S.K. Sinha, the learned counsel appearing on behalf of the petitioner, Ms. Udas, the learned additional senior government advocate appears on behalf of the respondent numbers. All the respondents. Pustu. The petitioner herein has approached this court being aggrieved by the non-payment of the various non-payment of an amount of rupees 62,47,160 to which the petitioner claims to be entitled to for supplying stationery articles, computer articles and electrical articles in terms of the several supply work orders, including orders dated 30/12/2019, 28/9/2020, 29/10/2020, 23/1/2021, 29/1/2021, 26/8/2022, and 35/2023. Full stop. The record reveals that on 26/6/2024, this court had issued notice seeking instructions as to whether the petitioner is entitled to the amount of rupees 62,47,160 as has been claimed by the petitioner. Today, Ms. Udas, the learned counsel appearing on behalf of the petitioner, has placed before this court an instruction issued by the Assistant Inspector General of Police, (TRG), who is the respondent number respondent number 6. Full stop. The said instruction, a perusal of the said instructions reveals that the respondent authorities duly have duly admitted that an amount of rupees 60,67,608 has been pending is the outstanding liability to which the respondent authorities are liable to pay to the petitioner. And on account of it has been further mentioned that on account of non-receipt of budget, financial sanction and sealing from the competent authority, the pending proposals of rupees 60,67,608 could not be paid to the petitioner. The instructions so submitted by Ms. Yudas, the learned additional senior government advocate, is kept on record and marked with the letter X. Full stop. Taking into account that this court is exercising the jurisdiction under Article 2 to 6 and disputed questions insofar as disputed and as an amount of as the respondents have only admitted an amount of rupees 60,67,608, and not the amount as claimed by the petitioner, that is rupees 62,79,798, this court would not be in a position to direct the respondent authorities to make payment in respect to rupees 62,79,798. However, as the respondents have admitted to the amount of rupees 60,67,608, and that too after due verification, it is the opinion of this court that the respondent authorities are bound, are statutorily obligated under law to make payment of the dues to which the petitioner has been admittedly entitled to. Accordingly, the instant writ petition therefore stands disposed of with a direction to the number disposed of with the following observations and directions. Footstep. The amount of rupees 60,67,608 which has been admitted by the respondents be paid to the petitioner. Within a period of 6 months from the date, the certified copy of this order is served upon the respondent number respondent number 3. Full stop. Number 2. In respect to the other amount which the petitioner has claimed, which is beyond the amount of rupees 60,67,608, this court would not issue any direction for making payment of the said amount. The petitioner would be at liberty to would not like to pass any direction in respect to the payment of the said amount. With the above observations and directions, the it will make it. Yeah. Oh, that is why. Okay, so that is not required. Here it has been said. Line to make it. Although the petitioner has claimed 62,79,798, an amount of rupees 2,12,190 have already been paid to the petitioner, and an amount of rupees 60,67,608 is pending. এই তাৰপিছত এইটো লিখিব accordingly the direction is to deposit the area. Last second direction to নালাগে. Yes, what is this? Non-payment on account of central capital subsidy. Have you filed the affidavits?
No, sir, central government has to file affidavit.
You are not going to file.
We are not
Chalo.
required to.
None appears on behalf of the central government when the matter is called. Full stop. The Industries Department, Mr. A. Kolita, appearing on behalf of the Industries Department, submits that the Industries Department is not going to file the affidavit. Full stop. Considering the central government is not represented, this court fixes the matter again on 11th of August 2025. Full stop. It is observed that if the circumstance the central government is not represented or do not file the affidavit on or before the next date, comma, this court shall dispose of the instant petition on the basis of the materials already available on the court. You have filed the affidavit. Why you have not filed? Somebody else does not file, why you are taking the responsibility? Don't file the affidavit. You see, this, I am taking a bench for after a long time. And this is not this year, last year. Last year, notice has been issued and the central government does not file the affidavit. You want more, some better observations? This is enough. Hey, appears. He submits that he is going to file the affidavit without fail by on or before the next date. Mr. I give you give an undertaking that you are going to file. Mr. R.K. Dev Chaudhary appears on behalf of the Mr. R.K. Dev Chaudhary appears on behalf of the respondents, central government, and submits that without fail the affidavit will be filed if 2 weeks' time is granted. Full stop. List this matter on 13th of August 2025, comma. The affidavit be filed by 11th of August 2025. Mr. A. Kolita, appearing on behalf of the Industries Department, submits that the Industries Department have no role to play for which the Industries Department would not be filing the affidavit. List according. Yes, what is this?
Nebulizer, Lordship.
Huh?
Nebulizer, Lordship. Lordship, kindly given 1 week time
For what?
I'll reply.
For what? Is
I'll
agreed
reply.
by the cancellation of the earlier tender process and issue of new tender by the interim order as private respondent have been offered the fishery in question at a lower bid than the bid offered. Let notice be issued. Since many name of the learned counsel is not reflected in the name of the form. Fishery given for how many years?
5.
5 years. 1 year has already gone. And you are not interested. Why should you?
Yes, sir. Engagement, my lord.
Fishery
Yes, sir.
Department, why nobody is appearing? Is the name of Mr. P. Sharma not reflected in the cause list? Huh? Reflected. Therefore, then none appears on behalf of the Fishery Department when the matter is. You are referring. Okay, why haven't you filed the affidavit? Huh? Understood. What is the basis on which the Deputy Commissioner has filed the affidavit? Has settled it with anybody? Can the Deputy Commissioner settle it? A fishery? Other than by the Fishery Department or by the AFDC, can a fishery be settled by the Deputy Commissioner? because of that notification issued by the governor on 7th of April 2000 something. How is it possible? What 60%? Deputy Commissioner will do it, but Deputy Commissioner does it under the aegis of the Fishery Department. Isn't it followed under the fishery rules? The Deputy Commissioner issues the notice. Deputy Commissioner does everything. But on behalf of the Fishery Department, it is done. Or no?
Percent. 60%. Deputy Commissioner issues the
Yes, Deputy Commissioner issues it. There's no quarrel with that. Yes, madam, why haven't you filed the affidavit? You does? Okay, what is your stand? Show me that. Why have you given to a lower bidder?
two certificates, Bhatija clearance certificate and schedule caste certificate.
So his bid was rejected. No, nothing.
Lordship,
Madam, I am not aware of this case, madam. Kindly fix two more.
Okay. None appears on behalf of the petitioner on call. Ms. Yudas, the learned additional senior government advocate, submits that an affidavit has been filed on behalf of the respondent. Has been filed on behalf of the Deputy Commissioner, District Commissioner, on 19/5/25. However, from the record, the said affidavit is not. However, the said affidavit is not on record. Considering the above, list this matter on 8th of September 2025.
Obligation.
Yes, Dr. Todi. Oh, this matter. Morning matters.
No,
This is also tea.
this is also,
Same tea development subsidy.
here. To root the bushes within that financial year. But it was spread over to the next financial year.
So here he has not been should not be set aside. Impugn letter issued by the mayor rejecting the petitioner's prayer for subsidy financial assistance under the special demand by the three boards should not be set aside. Completed field work for replanting, replacing and uprooting of the tree bushes as such was entitled to receive the subsidy. Okay. And your stand, you have filed the affidavit.
Yes, Lordship.
Reply has been filed. Okay, we dispose it of then on a date as may be convenient to Dr. Todi, when it is convenient. You have any urgency? Dr. Todi,
My lord,
when is convenient? Not in urgency?
not in urgency, my lord, but still
Huh?
it is pending, my lord, for long, my lord.
When do you want it? This year? Next year? Next to next year? Which year?
My lord.
This year?
My lord, is a subsidy matter, my lord, we are entitled to.
Yes.
My lord,
So
but-
therefore, delay does not make any sense.
Yes, my lord.
Let's have it on 19th of August at 2 p.m. Okay? So the pleadings are complete, considering the above and learned counsel appearing on, senior counsel appearing on behalf of the petitioner expresses urgency, taking into account the above listed matter on 19th of August 2025 at 2 p.m. An attempt shall be made to dispose of the petition on the said date. Yes, Mr. Chakraborty. What is this?
But it is that matter. The, the executive officer of Agriculture Municipal Board had enhanced taxes. The very first order was passed by your lordship.
Me?
Yes,
In this case?
yes, the first order was passed by your lordship.
Oh,
Thereafter, pleadings have been
not
exchanged.
inclined to issue notice. Herein who are 15 in numbers are resident of Silchar. It is the case of India, the Silchar has been dissolved and all powers and duties under the Assam area which is required to be exercised in India is presently performed. It is meant that the question was put without taking into account the ground unity and target to enhance the lake in an sovereign manner. It is also the case of areas that we say right from the part of India to the land only through commercial and business activity. You have filed the affidavit?
Yes. They filed the affidavit in opposition to which I have responded.
You have reverted. There is no stay?
There is
Oh. Chalo.
the basic contention that I raised in the writ petition was on two counts. First is, my lord, this arbitrary enhancement of the taxes, more particularly the water tax, along with the other taxes. This came to be known to the petitioners who were the citizens within the municipal area through a publication which was in the newspapers. Now, thereafter, mass protest was raised. The petitioners were also participants in those protests. Now, the law point involved here, my lord, that I have taken in the writ petition, that the mandate of section 68 of the Assam Municipal Act 1956 was not followed, wherein any decision of the board that has to be preceded by a prior notice. Now, to that, my lord, my senior was perhaps asked to obtain instruction and file an affidavit to the state. Now, they have filed an affidavit, and in paragraph number 7, they have stated that so far the budget is concerned, at page number 110, paragraph number 7, this is the statement specifically in response to the query put by this honorable court regarding whether there were notifications. Now, they have stated in paragraph number 7 at page number 110 that the statement made in paragraph 7 of the writ petition that municipal board without any notification or intimation has enhanced water tax and other tax is incorrect. And the deponent denies the same, that it is respectfully stated that deponent number 6, after going through detailed review over the existing collection and expenditure, decided to enhance the existing fees, tax, etc. in the budgets, in the board's budget for financial year 2024-25, and put forward the proposal to the state government, and after getting due approval dated 16/4/2024 over the.
So how much is the increase?
My lord, the increase, my lord, in respect of various taxes, that I had, my lord, put in my petition. That is there in paragraph number, your lordship can see, regarding the various enhancements. At page number 13, paragraph number 7.
Number 7.
Page number 13, paragraph number 7. So for the water tax is concerned, that was enhanced from rupees 125 to rupees 300. And then there are other taxes also which have been enhanced from the earlier dates to the new dates.
But you are concerned with the water tax.
I'm concerned with most of the, all the taxes, and more particularly the water tax.
Okay,
Now,
when was the 125 fixed?
my lord, this 125 was fixed at the time of the functioning of the previous board, which was dissolved in 2020. Now, at that time, the municipal board was being headed by the chairperson. It was an elected board. Now, I have also raised this point that the executive officer has been resorting to these kind of decisions, whereas it is a local.
And how much water is being given?
My lord, water quantity, my lord, that of course that instruction I don't have.
Mr. Dotto, what is the water quantity you give?
Lord,
Is it running,
there is a
is
timing,
it
ma'am.
running throughout the day, or is it only for hours, something like that?
Possibly some timings is there in the morning and in the evening. Now, on the top of everything, my lord, let my learned friend first answer the question that who has given him the authority to represent the mass people of the Silchar municipal area. Now, my lord, my instruction is this: almost all the citizens are paying the enhanced rate of rupees 300 per month. Now, if your lordship take my affidavit, the
No,
position of the
no, Mr.
municipality.
Dotto, I understand one thing.
My lord,
The role of the court is limited in respect to what should be the exact amount or how much should be. It's very
very
limited.
correct. My lord.
It is only on an infraction of the act.
Or if it is malafide or vitiated by
Very
arbitrary.
difficult to say,
Yes.
because this is a single person would not have any malafide against
Yeah, exactly.
the entire population.
Yes.
The question of malafide does not
My
arise.
lord.
So the only question is, is it in violation to the provisions of the act?
Not at all.
If it is violation in the provision, then only the court can interfere,
interfere.
but then also when it comes as regards public services, the court should exercise some self-restraint.
Exactly, my lord, the appeals court has time and again has said.
Is
that.
it?
And my lord, if I take your lordship to the affidavit, what is our position? My lord, if your lordship take the page 125.
No, let us first see what infraction of the act he has alleged. Then I will come back to you.
Right.
We finish it off by tomorrow too. What do you say? Tomorrow at 2.
My lord, tomorrow, my lord, I have a constitutional matter, it will take whole day. So that is the, my lord. it will
Okay.
come. Or any other day in the next week, my lord.
The instant writ petition has been filed. Heard Mr. D. Chakraborty, the learned counsel appearing on behalf of the petitioner, and Mr. S. Dutta, the learned senior counsel, assisted by S. Dutta, the learned counsel appearing on behalf of the Silchar Municipal Board. Corporation or board now?
Now it is corporation.
Corporation. The petitioners herein have joined together assailing the increase, enhancement of the various taxes by the chief executive officer for providing the amenities for enhancement with the various taxes by the chief executive officer. The record further reveals that this court, though had issued notice on 4/10/2024 and thereby fixing the next date for consideration of the interim prayer, but there is no interim prayer. The counsels appearing on behalf of the petitioner, counsel appearing, expresses urgency as there is no interim prayer. Upon hearing the matter, this court is of the opinion that a further hearing would be required, for which this court fixes this matter on 29th of July 2025 at 2 p.m., on which date an attempt shall be made to dispose of the writ petition.
Much okay.
Why is it so fat?
Mostly, let's say the tender documents and this, we have in it. Okay, here, let's say this respondent number 6 is a proxy of respondent number 7 to 11. And to that effect, we have placed certain materials before this court. Now, 6 and 7, respondent number 7 to 11 filed an affidavit, logic. And there we have to file a reply, logic, regarding some payment, because that are not disclosed by both the respondent number 6 and respondent number 7 and 11.
Respondent number 6 has filed an affidavit.
They have already filed an affidavit. We filed our reply also. But now the respondent number 7 and 11, they also filed an affidavit in opposition, against which we need to file a reply, lordship.
When did they file?
They filed 17/6, lordship. Short time may be given, lordship.
This year? Okay, he was enjoying, must be.
No.
Is a stay?
They, regarding lordship,
Stay.
not to finalize,
My goodness.
not to finalize.
17th of June in ages.
Not to finalize without the leave
My
of the court.
goodness. We do one thing. You file, we give you time for 1 year. We vacate the stay and then give it after 1 year. We file.
Will they frame
1 month is not enough for you, so we give it 1 year. We give you till next year, 2026, 22nd of 24th of 23rd of July. Fix it
if lordship,
and vacate the thing.
only one point is that lordship, he means the respondent number 6 lordship, he used everything regarding everything.
How can they be an interim? It appears from the minutes
not
of
to
the meeting
finalize
of the
lordship
technical
without leave of the court,
evaluation
that
which
is
we
that.
demand that after the evaluation of the technical petitioner, technical was held technically qualified and the financial bid of the petitioner along with others were scheduled for rehearing. However, upon a writ petition filed by the respondent number 6, the same was disposed of with the direction to the respondent to dispose of the representation. Mr. Sharma, the counsel in support of the interim prayer submits that despite the petitioner's bid was evaluated, it was learned that the petitioner was rejected. R. Gogoi appearing for the exercise department submits that in pursuance to the direction passed the authorities upon disposing of the representation by hearing had rejected the bid area, which was selected earlier for being qualified for opening the hearing. Was not heard. Since the petition prayer was once selected to be qualified for opening the hearing. What? We are not concerned. Here is a case your technical bid was disqualified. Rejected. Initially qualified, but subsequent to a filing of a writ petition by the respondent number 6, the representation was disposed of in such a manner that your technical bid was disqualified. So if that be so, what is response number 7 to 11 to do? Who are they?
Yes, Lordship.
Who are they?
They have their own wine shops and bars in the locality.
I'm not concerned with wine shop and bars of them, but
Yes,
whether
but
you
Lordship,
are, first of all, if a bidder is
Lordship,
not
kindly-
technically qualified, forget about response number 7 to 11, we won't look into their affidavit. If the response number, if the bidder is not technically qualified, then in that regard, his locus standi goes.
Thing is that Lordship, not a forum or a authority has given us a hearing regarding this because
Why? Hearing is
Yes,
necessary.
thing is that we have filed our technical bid, financial bid. Technical bid was open. It was intimated to us that yes, your technical bid is admitted and it is responsive. Then we have waited for opening of the financial bid.
So,
In the meantime, the authority have verbally informed us that your bid is rejected without giving any intimation, any hearing. Then we come to know a petition is filed before this court, making us a party, leveling allegations against us.
but the
And-
court did not pass any order on merits.
But
The
Lordship,
court
that is,
passed an order to
yes,
dispose of the
yes,
representation.
but it is misrepresenting the order has been, if Lordship kindly.
No,
say-
no, you see, technical bid
Yes,
stipulates that you are to perform these are things.
yes.
These are the things which are already mentioned.
Yes.
Therefore, your submission should be that as per the tender document, you are not technically disqualified. That's all. Submit it.
But they are also not technically qualified.
Forget about them. Forget about them. I'm only concerned with
Now,
you.
yes,
First, you
yes.
satisfy your case. Why you are thinking about others? Why you are disturbing Mr. Dekar?
No,
You are 7 to 11. He looks like.
no, Lordship, if Lordship sees, there,
First,
there be,
I come back at 2. I don't have, my matters are getting over, so we finish up this.
then Lordship, one day may
Why?
have preparing.
Okay, tomorrow, 2 o'clock. Leave the matter tomorrow. Having heard the matter at length, tomorrow, leave the matter tomorrow at 2 o'clock for disposal of the petition. And attempt would be made to dispose of the petition. Which I am fixed it on 31st at 2 p.m. That was pertaining to one workman who was working out there in, because of opening the water valve, the pesticides out there could not be given. The pesticide for which he was terminated. After his termination, and you took up the matter in the labor court, and then you were appearing also out here on behalf of the workmen. That was a case where they had referred to Exhibit 13, and primarily their case is on the fairness of the preliminary inquiry. Yesterday, there was one item I put it as parted and all, but I didn't finish it only on the ground that you were none appeared for respondent workmen. That was some tea state, Parbat Peru, what the name? Oh, Liscon. Huh? Something like that. I'll give you the name. It was a hearing. Yes. Patapgur Tea State. You were appearing for Hiran Bhumis. So,
Unfortunately, the file has been taken at it from me. There was an application for under 17B for a long spell of time.
and that is why he must have lost interest.
Uh-huh.
But we help him out. Huh? On
But
31st,
then-
I have 24th, no, 31st. 31st,
What 2 or 3 years you could not procure this out.
understood. So that is why That
is
day
he lost confidence
yes.
on me.
No, he is also, the question is, he's not interested, means that,
Correct,
that
chronic-
person concerned having not received his 17B
Right, that
and the application being pending, he must have thought that nothing has been going on. But anyways, I put it as parted, so it will be taken up at 2 on 31st. Only,
is not all that.
only on the aspect as regards the fairness of the disciplinary inquiry, that aspect. Because their only question is, there were on 4 grounds. There were 2 orders. First, there was an order passed by which it was held that it was not fair, not
Oh,
fair.
yes. Now I
And
Now,
thereupon,
only one thing, that when the inquiry is declared unfair, the materials on record of that inquiry cannot be considered in subsequent inquiry.
yes,
There is a case,
yes.
covered case.
But there was an order being passed that it should be taken, but in spite of taking it, it went against the management.
Yes, now,
But, and the management were duly given the opportunity to adduce evidence, the management did not.
yes,
On the other hand, the workman adduced 2 witnesses on merits.
yes.
So that is
Now,
the
once the inquiry was declared unfair, they approved before this honorable
High
court.
Court. And the High
And the
Court said,
honorable High Court remanded it back.
Ah.
Then they were given an opportunity to adduce evidence as fresh. But instead of doing so, they again relied upon the inquiry proceedings.
But there was an order being passed by which it was permitted to tender that same evidence.
Same evidence.
And that way was allowed. But in spite of that, the court, and their main on merit was only on that exhibit 13,
Yes.
where he says that he has accepted that guilt, which during the cross-examination of the workman categorically stated that this is not my signature, I don't own this document. So that nothing. So his only argument is on the fairness of the inquiry.
Yeah, whether the materials on record, which was declared as unfair, can be relied upon again. That is the question. There is a Supreme Court case.
So you kindly help me out on 31st. No, file is not required. Only thing is on the point, law point, only on the fairness.
Your lordship can engage me, then I can.
Yes, on 31st.
Because he lost interest on me, because probably I could not give him due relief.
No, I understand. A 17B application
long
being
spell of
pending
time
from
is pending.
2019, not 2009. This is a matter of 2017, 2019, the 17B application has been pending. And that it must be the reason why.
When it came to it got adjourned. That was the problem.
And when they have not filed an affidavit also to the effect. So yesterday they said that, okay, we are ready to pay 17B. I said, where is the question now? Paying 17B, take it up now. We finish it off.
When the date fixed?
31st at 2 p.m.
The lordship pass an order whereby I will, well, because I gave him a note that no
It's
objection.
okay. I will record, I will ask him to, for your assistance as a senior counsel only. Yes, what is this? Oh, your matter. Where is the other side? So many affidavits, additional affidavits filed.
My lord, in fact, the latest one that was, my lord, filed yesterday. Now, this is in pursuant to the order that has been passed on the last occasion, my lord. On 27/6/2025, the last order that was passed, pursuant to that, I have filed.
So these are the documents to show that you are economically backward, economically a weaker section. So therefore, the only thing what can be done is notice has to be issued. It cannot be finished up like this.
That is why my prayer always, my lord, from the very beginning was for issuance of notice, but somehow, my lord, initially the additional affidavit was for bringing the entire scheme on record that I have done. Now, by way of this affidavit, I brought the relevant documents which were asked of. Now your lordship takes into consideration, my lord, and notice has to go. My lord, my only impediment here is in respect of that clarification in regard to those 2 orders from this honorable court in 2 different writ petitions, which are in no way an impediment in me getting the relief.
we are asking for benefit from the scheme. If we are entitled to, we get it. If we are not entitled to otherwise. we
So
do
your
not get
case is that they are not considering your case for for the benefit of the scheme. That's your case. So if that is the same, it is the respondents who have to give us good reasons why they are not, and then we'll take it up. Well, but where is the central government? No central government. Where is central government? There's no on behalf of business. Central government council has to be either a panel council or a council who has been authorized by the central government. How can you accept notice on behalf of anybody? There's no on behalf of business. Can there be an on behalf of? No. So where is the central government? Their name has been reflected in the cause list. Yes, DYSCI. What is it now? Okay, issue notice, making it returnable on 18th of September, 19th of September 2025. Full stop. Mr. R.K. Dev Chaudhary appears on behalf of respondent number 1. One. Miss Yudas, the learned additional senior government advocate, appears on behalf of the respondent number 2. Social welfare also. 2, 3, then 4, 4.
Separate.
This is by central government.
Separate.
This is the central government. Five, and the project director? 7, 8, and 9. Mr. R.K. Dev Chaudhary appears for 1, 4, and 5. Extra copies of the writ petition along with the additional affidavits be served upon the learned senior and learned counsels appearing on behalf of the respondents within 3 days. First up. The case of the petitioner herein is that the petitioner, though entitled to under the Pradhan Mantri Awas Yojana Urban, though entitled to the benefits under the Pradhan Mantri Awas Yojana Urban, have been deprived of the same on the basis of on a wrong and a misconceived notion adopted by the respondent authorities in pertaining to the judgment and order dated 28/7/2015 passed in WPC number 811/2008, as well as the order dated 2/12/2021 passed in WPC number 6392 of 2021. The learned counsel appearing on behalf of the petitioner submits that the said judgment as well as the order passed by this court have no relevance as regards the entitlement of the petitioner to the benefits under the Pradhan Mantri Awas Yojana Urban, and the respondent authorities have, relying upon the said judgments, have denied the benefits, which amounts to malice in law. First stop. Taking into account the above, the respondents are directed to bring on record their stand by filing the affidavit on or before 15th of September 2025 as to whether the petitioner is entitled to consideration and is entitled to the benefits under the Pradhan Mantri Awas Yojana Urban. First stop. List accordingly.
My lord, I have some instruction that, my lord, some amount of has been received by the petitioner, my lord. I could not contact last 2 days, my lord, whether he has received entire amount. Yes.
As for my telephonic instruction, some payment has been made, but the amount has not confirmed yet.
So 1 week time, my lord, I'll get.
1 week time maybe given, Lordship,
For
for verify whether how much they have paid, Lordship.
it is seen that by an order dated 11/12/2024, this court issued notice seeking instructions as to what amount the petition, as to whether the petitioner is entitled to the amount as claimed in the writ petition. Full stop. Ms. Jibora,
Lordship,
appearing on behalf of the Agriculture Department,
Lordship.
submits that that a week's time may be granted so that she would be in a position to place the instructions as regards the petitioner's entitlement. Full stop. List this matter again on 11th of August 2025. In the meantime, the council appearing on behalf, the standing council appearing on behalf of the Agricultural Department shall apprise this court as to whether the petitioner is entitled to the amount as claimed in the writ petition or any other amount.
But we have admitted the amount.
Admitted. It is disposed for you. Payment within 6 months. Affidavit of copy. You have a copy? Give it to me. Hey, এখন affidavit of copy দুখন ভৰাই ৰাখ। এইটো চাই ল'ব দেই, ভিতৰত চাই ল'ব। তাত কি লিখিছে admit কৰিছে কোনটো payment। Post. Another man. Mr. Bottakur have many men.
I claim less, my lord.
In this case, my lord, he claimed less, madam, 81,946.
Huh?
He claimed less amount, my lord, amount 81,946, but he claimed less, my lord. Lordship may be pleased to pay it. Yesterday we have filed the affidavit. So.
How much he is entitled to
19 lakhs
Nine-
54,481.
481.
as per the affidavit? You have a copy? So we direct this payment to be made from 19 lakhs within 6 months. There's no question of verification because it is on affidavit. Itu paragraph 5 to put of the affidavit. You have also stated there na, in the earlier one. Huh? To paragraph, yeah, they filed an affidavit, the details of which admitting to the liability of an amount of rupees 19,54,481. Most of the details can be seen in paragraph number 5 of the said affidavit in opposition, which is reproduced here in under, taking into account the said amount, the direction. And this, this is police,
Yes.
the DGP, certified copy DGP within 6 months.
Problem.
Earlier one also police.
Yes, ma'am. Payment of the supply bills, my lord. It is supplied the relief materials.
My lord, the department is praying for another 3 months' time to examine the whole matter and then we will come up.
I give you 6 months,
Yes, for
verified pay.
In fact, my lord, the similar situated persons case.
Not necessary. Dorothy order. Yeah, Bhattaji submits that that the entitlement of the petition, that the petitioner would be entitled to, as regards the Mr. Bhattaji submits that the verification process is going on and submits that as regards as to whether the petitioner is entitled to, that would be subject to carrying out necessary verification, taking into account the thing. So Dorothy's order to Pasta, all separate orders.
6 months. Within a period of
6 months. Verification, everything 6 months. Everything.
Must be.
It's non-payment of contractual dues, your lordship.
No, here we'll require affidavit. This is not a simple matter of non-payment. Here there is a rejection.
Five.
This is by
I'm sorry, I think
Desras Khamra.
My lord, from 39 to 44. This maybe keep part of record, this instance. That will be better for me.
Has placed before this court an instruction stating that the verification is going on, which is kept on record and marked with the letter X. Give 6 photographs for photostat copies. X mark kori, Yes, Mr. Sharma.
Item 45.
They have instructed that due to paucity of fund, the payment cannot be made. But
No, your reason, are you aware of that? Why here the petitioner is challenging an order by which the petitioner's entitlement have been refused on the ground that no sanction from the chief executive officer has been made, which is
yes,
incorrect, taking into account that in the annual plan, the chief executive have approved. So therefore, this would amount to setting aside that, interfering with that order and directing you to pay. So you agree that there was a mistake.
yes, that there was a mistake, but now they have instructed, verbally they have instructed, and I have prepared affidavit on that basis, and I have sent them for signing lordship.
Oh, fantastic. Mr. C. Sharma, the standing counsel of the respondent numbers 2, 3, 4, 5, and 6 submits that an affidavit has been already been prepared and has been sent for vetting, and it would be filed in a week's time. Full stop. Taking into account the above, list this matter again on 13th of August 2025. In the meantime, the affidavit be filed without fail by 8th of August 2025. It is observed that if the affidavit is not filed, this court shall dispose of the instant proceedings on the basis of the materials already available on record. Non-payment. Yes, who is appearing? Water resource. No water resource. Your water resource. Who is the junior D. Jane?
Lordship,
Who's junior?
There
The problem arises. First of all, you should not issue notice except allow these juniors to accept the notice.
instruction has been received, Lord. Instruction has been received.
Take a look. So you admit it. The current outstanding contractual dues to the petitioner stands at rupees 1,29,47,000. Okay. Mr. C. Sharma, the learned counsel, appearing on behalf of the Water Resource Department, submits an instruction issued by the executive engineer Hailakandi WR division, wherein it has been mentioned wherein it has been duly admitted that the petitioner is entitled to an amount of rupees 1,29,47,928. It has been further mentioned that there is some part payment made.
Total was 1 crore 72 lakhs. Out of that, they made a payment of 42 lakhs. So the
Ah.
balance amount is.
It has also been admitted that out of that earlier, an amount of rupees 42,56,900 was already paid to the petitioner. And thereafter, the remaining entitlement of the petitioner is rupees 1,29,47,928. Further to that, it has also been stated that after due verification on the basis of the materials, administrative approval which was taken had expired on 7/2/2023. And in that regard, a proposal for revalidation of the scheme has been submitted to the concerned authorities and upon receiving, the demand for payment could be submitted to the concerned authorities. First stop. The said communication, the enclosure, first stop. The instructions so placed full stop. It further appears that the said instructions as well as the parawise comments have been forwarded to the learned counsel appearing on behalf learned standing counsel of the Water Resource Department by the Assistant Chief Engineer, Water Resource Department. Full stop. The same is kept on record collectively and marked with the letter X. Full stop. This court therefore inquired with Mr. C. Sharma, the learned counsel appearing on behalf of the Water Resource Department, as to how much time would it require for making the said payment, as the amount to which the petitioner has claimed is duly admitted. The learned counsel submits that there are certain formalities relating to revalidation of the administrative proposal, a revalidation of the scheme, which would take some time. First, accordingly, so taking into account the above, this court disposes of the instant writ petition, taking into account the above materials on record, taking into account the materials on record as well as the document, as well as the material documents which are kept on record and marked with the letter X. This court disposes of the instant writ petition with the following observations and directions. Number one, the petitioner admittedly is entitled to an amount of rupees 1,29,47,928. Number two, the respondent authorities, the respondent authorities, more particularly, the respondent number 2, 3, and 4 are directed to do the needful for the purpose of revalidation of the scheme. Are directed to do the needful, and thereupon make payment to the petitioner of the amount of rupees 1,29,47,928. Full stop. Number 3. This court directs the said exercise be completed by the respondent number 2, 3, and 4 within 6 months from the date a certified copy is served upon the respondent number 2. আগৰ এইখিনি লিখি দিব দেই এই কেছটো কি হাৰ্ড মিষ্টাৰ সো এণ্ড সো দিস দ্য কেছটো এইটো হোৱাট ইজ দ্য ফেক্টছ খিনি আগৰখিনি লিখি দিব এইখিনি পিছত আগৰখিনি লিখি দিব
I'm okay.
Yes, Mr. Barbuzari. You're a bench 5 or where? Don't see you or finance has no role. Yes, one thing very important. Today, there's a series of matters. This is very important as you are your finance. There's a series of matters today where I passed an order directing the commissioner PNRD to file an affidavit. Now, what was happening during the period in 2018? Various supply orders were being made by the chief executive officer, some Zilla Parishad. They were directing them that you supply me this, that, whatever may be, but no rate fixed. Is it permissible?
Because Lordship will kindly recollect, even at the time of flood season, where funds are released by under SDRF or NDRF heads, then also, my lord, it is called RG, rehabilitation grants. So for example, there is sudden flood, so there is a urgent need of construction of an embankment, or people are to be sheltered in makeshift homes. There, my lord, temporary contracts are issued, work orders are issued, but then also rates are fixed.
Now, what is happening? They say that you supply us 2,000 quantities of this, 2,000 quantities of that, 1,000 quantities of this. Okay. Then in 2000, that is in 2018. 2019, they submit the bills with certain rates. Now, that payment not being made, they have come before the court. Now, the question is, can they issue this type of supply orders? So I've asked the Commissioner PNRD to file an affidavit. Is it permissible? Because if not, okay, this is being done, it's done. It's a different aspect to the matter, but it has to stop this type of actions.
Contract without consideration is void. That's
Well,
it.
then, so that is what. But today, when I was passing that order, I didn't find a finance lawyer. So I didn't make the finance at the party because finance needs to catch hold of this PNRD because they cannot do this. Let's see what the commissioner files an affidavit.
They have to give justification otherwise.
How will do
can
that?
they bypass statutory requirements?
Chalo. Okay, Mr. Hussain, tell me why this is 47 contempt.
Here
Why the contempt has become so big?
oh my lord, I will explain, my lord. I am here in a catch-22 position, my lord.
Okay,
The,
let us.
the difficulty here is that, my lord, the original order was passed, my lord, by the learned single judge in repetition. Way back in the year.
Disposed of in line with that order.
Yes,
The exercise be carried out within 4 months. Now,
Yes.
where is that order? The petition sent this over with the direction to the state to make compensation for the damage caused to the movable of the members of the petitioner society on the basis of assessment reports prepared by the Forest and Revenue Department. While ascertaining the same, the quantum of compensation payable it would be at the discretion of the state to limit the amount to a maximum of demand per family, less the amount. Necessary action for taking the effective steps towards compliance to the direction above by the state within a period of 4 months from today. How many people are there?
if the, my lord, large number of persons are there, these, if you have
Once this matter must have come up before me. Yeah, in the meantime, that's why it's directed to bring on record as to whether the verification as directed by this court passed by has been completed or not. And if not, the reasons be assigned.
Yes, pursuant to my lord's order, the respondent number 10, whom I am representing, the principal secretary to the revenue department, he is the prime respondent here. So he has filed an affidavit on 14th of February 2025, That affidavit starts from page number 28, running page number 28 onwards.
14 February, 25th February. Yes,
Yes, my lord. Running page number.
yeah, I've got it,
Yes,
25th
yes.
February.
There, my lord, we have made a statement, my lord, categorically that we have sought for the reports, my lord, from the district commissioner, my lord, from all these districts, because it will be a,
To state in the meantime, the joint secretary so requested that the commissioner here to examine the matter and accordingly submit the necessary proposal and so and so. This was done in connection with compliance to the order dated demand. And then by the order, the joint secretary then requested the district commissioner so and so to take necessary regarding submission of detailed report. And then a meeting was held on so and so regarding rehabilitation of the families affected by so and so. Held on demand wherein it was decided that the two concerned will complete the exercise within a period of 3 months. The verification of the families who have received rehabilitation of 10,000 rupees and by following name. It will request to complete the exercise for furnishing the report as per the format. It stated that later the joint commissioner requested the district commissioner of proposal to ensure to submit one for the action taken for How much time you require?
now, my lord, pursuant to this, my lord, since we have sought for the reports, my lord, from the concerned district commissioner, some reports have been received. And now, my lord, the government has taken a decision, my lord, to constitute a cabinet subcommittee. My lord, that is, my lord, communication on 16th of this month, last month.
They are claiming the entitlement on what basis?
They are claiming the entire,
On some scheme.
some scheme, my lord, they say, my lord, rupees 10,000 was given to all the affected families. And there were 4 categories of affected persons which were called out by a policy decision of the government. Those who are affected partially, those who are partially not affected, those who do not have any homes to go, those who were rendered completely homeless and they didn't have any money. For those category of persons, a one-time grant of 50,000 was promised to be let out. They say that they fall within that category. We dispute. Now, my lord, in the first petition, my lord, filed by backs of my lord, one another organization, NGO, that was disposed of. And there, my lord, the detailed order was passed. They claim to be similarly situated person. They filed the second writ petition, this writ petition, my lord, claiming benefit of the earlier judgment. Now, this writ petition was disposed of in terms of that earlier decision, my lord, like 2015. Now, lordship will
Problem arises when all these joint petitions are filed, na?
yes. Now, my lord, against both these,
Now, these are the petitioners. The 11 petitioners have not received.
yes. Senator.
Petitioner, they are
Yes.
representing the organization.
Where is the representation?
It is in the writ petition.
No, forget about the writ petition. I'm not bothered out there. We are only concerned with these 10, 12, 11 writ petitioners. The contempt petitioners.
Now, kindly said
Both
against these orders passed by the learned single judge, the state filed appeal before the honorable division bench. Honorable division bench was pleased not to interfere with the appeals filed by the state, and those were dismissed. Against that, state has again filed review, to bring on record the very basic that whether there was a decision of the government to increase rupees 10,000 to 50,000. Admittedly, they were 10,000. They are claiming more. They say that they are rendered homeless. This is a question of fact that has to be verified upon. This incident happened way back in the year 1996-98, my lord. Now we are in the year 2025. It is humanly possible. Possible, kindly also have a look of the review, my lord.
What
The
happened? Review what happened?
Review, my lord, on last 4th of March, it was listed. My lord, I had assisted the learned advocate general. On the request of learned advocate general, my lord, the honorable division bench has granted us some further time, my lord, to place on record, my lord, the decision of a committee to, my lord, to refer the matters for, my lord, increasing the contempt from rupees 10,000 to 50,000. That is not on record. In fact, that was not on record even before the Honorable Single Judge. Nonetheless, Honorable Single Judge has decided that no, since some persons were given 50,000, they appears to be similarly situated, so make a verification exercise. Yes, make a verification exercise and do it. We are.
Anyways, why I am only an executing authority. I have no. Anyways, we do one thing.
What?
No, it's okay. No, Mr.
Milo.
Mr. It's okay. That is you do one thing.
Now,
This, you, from the affidavit which has been filed by the respondent number 10, it appears that you are taking certain actions.
cabinet subcommittee, cabinet, yes,
Understood?
yes, this is
And
I-
there
I
is
got
the
it.
formation of a subcommittee to further look into this aspect.
Milo,
So we give you another 4 months
Milo,
and give us an update.
Milo.
I
Absolutely.
think this is a fair.
They are, why to deprive them, Milo?
No, the problem arises when so many petitioners come, na?
Remember, not possible.
I think 1,000 cost has to be imposed upon the petitioner council for each petitioner in the writ petition. Okay, no, you are not doing anything free service. 1,000, no, because of you, this has happened. If these are particular writ petition, you have brought in 400, 500 people together and asking for filing. So 1,000 rupees, they will be good for the legal service authority.
Since 2011, these people are not litigated. Coming courts, one after another, whatever past, their complaints as
It
contempt.
should have
earlier
been,
also there,
this matter
That is
should
why
have been nipped
Malad-
at the bud only. Absolutely, it is the discretion of the state to grant or not to grant, that is their look.
That is correct, But same.
Anyways,
Mm,
Gustav,
the
it is seen that pursuant to the order passed by this court on 3/1/2025, comma, the respondent number 10 has filed an affidavit detailing out what steps have been taken for complying with the judgment and complying with the directions passed by this court dated 27/3/2017 in WPC number 4337/2016. Full stop. This court is aware of the fact that the verification which is required to be made pertains to the late 1990s, pertain to incidents occurring in the late 1990s, comma. Under such circumstances, comma, this verification would definitely require some more time. Full stop. It has been also brought to the attention of this court by Mr. R. Borpuzeri, the learned counsel appearing on behalf of the Finance Department,
Respondent 10,
appearing on behalf of the respondent number 10, that in the meantime, the governor of Assam also, in order to ascertain the entitlement, have constituted a cabinet subcommittee comprising of various members by the notification dated 16/7/2025. Full stop. The said document is kept on record and marked with the letter X. Full stop. In that view of the matter, as there is already a subcommittee who is looking into the said aspect, comma, it would be in the interest of justice that some further time be granted to the contemners to apprise this court as regards the compliance to the directions passed by this court. Accordingly, list this matter again on 10th of November 2025 for further an update.
So, like,
Yes. What case?
Petitioner has applied for under the scheme of national mission.
Stop the national mission on food processing. As a result, no fund is available by the central government. Therefore, question of considering the claim of the petitioner does not arise. What case you have? Anyway, today is fixed for orders. You will say no acceptance have been received by the section till date regarding service upon respond number 6. Who is respond number 6? You have served or not?
It's not.
You are not interested. All the problem is being caused by the respondent number 6, and you are not serving a copy. Matter pertains to 2019. So, 2025, 6 years, you have not been able to serve a copy of the respond number 6. So we strike out the respond number 6 first. After striking out, Mr. Ekolita will make a submission that the instant writ petition cannot proceed with the respond number 6. So on that ground, we dismiss your writ petition. Okay. Ms. So-and-so, what is name? So-and-so appearing on behalf of the petitioner submits that during the course of the day, a copy of the writ petition would be served upon Mr. R.K. Dev Chaudhary, the learned DYSGI. Full stop. You are the central government. Would serve upon Mr. K. Gogoi, the learned central government standing council. Full stop. Taking into account the above, list this matter again on 22nd of September 2025 for admission.
Has been
Yes, contempt.
complied with law.
Complied. Mr. Dinath, the learned counsel appearing on behalf of the respondent. So respondent submits that the amount have already been paid to the petitioner. And in that regard, have placed before this court the communication dated and have paid before this, had already been paid to the petitioner.
I have
Full
the
stop.
communication.
In that regard, he has placed before this court a communication which is kept on record. Which have placed before this court a communication dated 21/3/2024, communications dated 21/3/2024 and 2/4/2024, which are kept on record and marked with the letter X and Y. Full stop.
Next, the second communication is for the next case.
Oh.
Two cases.
Which one you want? 21
21/3/24 is
for this case?
item 49.
What kept on record and marked with the letter X, communication dated 21/3/2024. The learned counsel appearing on behalf of the petitioner also submits that the petitioner have received the amount. Full stop. Accordingly, the contempt proceedings stands dropped.
Same for next side.
Second is 2/4/24.
Same.
Communication is
Item
15.
50. Same. Etu khali 2/4/2024 hobo. A2X.
Oh,
I don't know. Sisi. 51. What is this matter?
There's just an award, my lord. The writ petition is filed by Apollo Hospital. I am representing the workman, the sole respondent.
Mr. Dasgupta, you are starting to appear for the management.
That was compulsory because of that.
Yeah. Anyway, chalo.
Bubble.
The records have been received. So when should we dispose it of? This already the rule has been issued. So we finished it. I don't know till when I am going to take up this bench.
You have fixed the date of hearing already.
Okay, second of
Record, lower court record has come.
it has come. On 2nd of September. Good stuff. It is seen. I was heard Mr. A. Dasgupta, the learned senior counsel, assisted by Ms. K. Kolita and Mr. S. Chakraborty, for the petitioner and Mr. S. Chakraborty, who represents the respondent
Only,
number,
all respondent.
huh?
Respondent, only one respondent.
Respondent number 1, full stop. It's a case of, yeah, reinstatement.
With full back wages. And there is an order passed under 17B also.
There's already, you
Yes.
are getting that.
We are
Yes, he is
that.
getting that.
I'm getting that.
The present proceedings pertains to challenging an award dated 21/7/2023 passed by the Learned Labor Court in case number 02/2022, whereby the respondent herein was directed to be reinstated with full back wages. Full stop. The records of the Learned Labor Court have been duly received. Full stop. There's an urgency expressed by the councils for an early resolution of the instant dispute. So considering the above, list this matter on 2nd of September 2025.
So I have filed wakalat now. My name is not reflected in the cause list.
What?
My name is not shown in the cause list.
I will call it.
Yes, I have filed wakalat.
You are there? Yes, what is this?
In terms of order 13.6, my lord, we have submitted the amended cost title, including the respondent 8 and 9. At this stage, my lord, notice may go to respondent 8 and 9. In all this. Same respondent, my lord, arising out of the same order, my lord, contempt.
Have you informed the respondent number 8 and 9
Yes, my lord.
about the case?
My lord.
Where?
I have stated in the case, my lord, I have furnished with the copy. The case was allowed.
To me?
Yes, my lord.
Are you concerned? Because they get a issue notice upon the newly pleaded respondent number
8 and 9.
8 and 9. Oh, returnable by 22nd of September. Good evening. Steps be taken by way of registered as well as usual. Liberty given to effect service by way of dusty, routed through the registry of this court and file an affidavit of service on it.
Order just bit lordship 22 and operative part is with page 37 lordship paragraph 21. So payment was directed to be made within 15 days.
Who is respondent number 1 and 2? Yes, Mr. Folia, what is wrong with you?
Here, this is a contempt matter regarding PWD lordship. Mr. B. Gogoi appeared.
Who is appearing for this 1 and 2? Sandan Sharma and Abdul Mutin Chaudhary. You are appearing.
So he appeared lordship taking time. No, lordship. Here, lordship.
Yeah, it says on 6/6. Heard Mr. P. Sharma. Also heard Mr. A. Solia, the learned counsel appearing for respondent number 1 and 2.
Lordship, here I appeared on behalf of Mr. B. Gogoi. Lordship, today he could not be here because of a medical emergency. So,
What happened?
Lordship, he had to go to Lakhimpur because of his reserve.
He's an additional advocate general. He cannot appear in contempt matters.
Yes.
You have to appear. Now you tell me.
Lordship, here.
You took time to file the affidavit in opposition.
No, Lordship, here some instructions were received, Lordship. That is.
No, I don't understand, Mr. Counsel. How do I take care of this? That there is it needs to clarify that since the aforesaid content had received notice and so respectively, the affidavit, if not filed by the next date, necessary order as required for securing the appearance shall be issued. Now tell me why I should not. You have not filed the affidavit.
No,
So therefore, we'll ask these the 1 and 2 to appear in person.
Lordship, there we have received the instructions.
I'm
Lordship.
not concerned. Why haven't you filed the affidavit? Either pay cost or affidavit. Which one? Of appearance. Which one? Either of it. Because I have to do something. Because there is already an order that there will be a direction for issuing appearance.
Lordship.
So I have to go with either, or I have to impose a cost and a cost upon the lawyer.
Lordship will impose the cost.
25,000, 25,000, 50,000.
No,
Mr. Solia, don't think this is the cost, this the court is going to use a cost of 2,000 or 5,000. No, I believe minimum is 25,000 and then it goes up to a lakh. 25,000
Lordship,
each.
here, Lordship. And I will just seek an accommodation for 1 day, Lordship, because Lordship, here, this matter was, I had appeared, Lordship, upon instructions, Lordship.
There's no mention that assures, A Solia, learned counsel for the assures.
Lordship.
Or are you saying that this judge concern
No, no,
is
no.
wrong? Then
I'm not making that submission. That so I will, Lordship will,
so you are making statements against the judge. Wouldn't that be a contempt?
no, no.
Oh, we initiate suo motu contempt
No.
against you.
No, Lordship.
No, no, no. I think you are putting a stigma on the judge,
No, Lordship.
the honorable judge of the High Court.
I have,
We should impose, we should initiate contempt
No.
against you. No, no. You made a statement out there. It is recorded out there.
no,
Proof
Lordship.
is there.
Yes, no, Lordship, I'm not
No,
disputing.
no, you said that I didn't know anything. I had only appeared on behalf of someone. So therefore, now the question is, how do I take care of this? First, you put a stigma on make some assertions against the judge that the
No,
judge
no,
is
Lordship.
wrongly
I have
written.
no, I have no intention of doing.
You
Lordship.
have done it.
No.
It is on
No,
record.
Lordship, inadvertently, I might have, Lordship. I've
Now
been
the
unable to-
cost, 25, 50,000.
Lordship, that, Lordship, I will I am taking responsibility, Lordship, but
So last time also you took the responsibility.
Lordship,
The responsibility you failed.
Lordship, here,
So 25, 50,000.
Lordship,
And not to you, to the legal service authority.
Lordship, that, here, Lordship, may just pass over the matter for the timing.
I don't have. I'm rising. Matters are finished.
Lordship, I just want to go, some instructions have been received. Let me
Go
just.
through last item of the
Yes.
list.
Lord.
But it was dismissed for default.
Lordship,
By whom?
Lordship, Honorable Justice. Case 14, Lordship.
Yes, why do you want this to be restored?
Lordships, on that particular day, Lordships could not be appeared.
Huh?
That particular day, when the.
You did not appear for 3 dates. This is there in the order. Then 15, 15, 15, 45,000 cost.
Lordship, it will be,
45,000 cost.
Lordship, that if.
No, the amount which you are claiming is how much?
Lordship, altogether, yet I have to get 26 lakhs.
23 lakhs 88,000. 45,000 is peanuts.
Lordship, if any,
Then go to the civil court.
Lordship,
I'll say it shall not be a bar to the trial petitioner to appear before a civil court. No. Either pay this 45,000. Legal Service Authority, do some good things.
Lordship, to some extent, Lordship, there is a little fault of the.
Not little fault, 3 faults.
people,
Then,
The councils also,
then
Lordship.
the council's mistake. So I'm imposing on not in the petition, on you. 15, 15, 15, like I was doing it for Mr. Solia, 25, 25. For you, 15, 15, 15, which makes 45,000. Don't think about the petitioner. You are saying about the council's mistake. You are the council who has committed the mistake. Can't help it. 45,000.
Lordship, it will be heavy burden on.
No. Then let's put it on the petitioner. Whom do you want? Don't say that you are the mistake of the council. One occasion is okay, but not twice. Twice is okay, but not twice. We still have a saying out there, once bitten, twice shy. This is once bitten, thrice shy. Let's dismiss it. Go to Supreme Court, division bench. The division bench won't lie against this. Supreme Court. Heard Mr. R. Sharma, the learned counsel, appearing on behalf of the petitioner. Mr. C. Sharma appears on behalf of the Water Resource Department. Mr. S. Dotto appears on behalf of the Revenue Department. The instant application has been filed seeking. Revenue Department is there.
Was this reflected?
Deputy Commissioner is there, na? And no, water in wide revenue. Revenue number 6 is okay. TR Gogoi did you? TR Gogoi appears for the. Mr. C. Sharma appears for respond number 1 to 5, and Mr. TR Gogoi appears for respond number 6. This is an application filed seeking restoration of the writ petition, accompanying writ petition, which was dismissed for default by an order dated 24/6/2025. Full stop. This court have duly taken note of the order, the said order dated 24/6/2025, and revenue is being given because there's a reason why. Because Mr. K. Gogoi, who was appearing in behalf of the government, submit that the instant writ petition cannot be proceeded with because this is under the SDR. The Revenue Department had to be made a party. And he has not then also complied with. Has been dismissed by an order dated 24/6/2025 on the ground of non-appearance of the petitioner. Full stop. It is further seen from the order that the petitioner was not represented on the earlier 2 occasions, and it is under such circumstances, earlier 3 occasions consecutively, and it is under such circumstances, the writ petition was dismissed for non-prosecution. Mr. Ashoma, the learned counsel appearing on behalf of the petitioner, submits that it was the fault of the council, isn't it? Mr. Sama? Fault of the council, for which the writ petition got dismissed. First, considering the same, as a client should not, a litigant should not suffer on account of the mistake of the council, this court, for the ends of justice, restores the accompanying writ petition, thereby recalling the order dated 24/6/2025, passed in WPC number 4408/2020. The writ petition is accordingly restored to the file of this court. Next, this court further takes note of that the council, that it is the mistake of the council, and the council had for the last 4 occasions, for 4 occasions consecutively did not appear. Full stop. And the reason so given is only in respect to non-appearance on 24/6/2025. But there is nothing mentioned in respect to the earlier occasion. Full stop. The conduct of the council, full stop, in the opinion of this court, cannot under any circumstances be said to be a professional and the conduct of the council appears to this court. That the council was not professional. Though they are bound under the Advocates Act 1961, as well as the rules of the Bar Council, to take steps when they take up the case of a litigant. First, as a measure of deterrent, this court imposes a cost of rupees 15,000 upon the learned counsel, Mr. So-and-so, who shall deposit the said amount within 7 days from the date of passing of this order. It is observed that if the said amount is not deposited, the matter be again placed before the court. Out of 45, we made it 15. Mr. Sharma, this is not done. Yes. 5,000 less, 10,000. 10,000. This case disposed. I can. And you file your application. File an impleading application now. Because unless you bake the revenue, you cannot get any relief. Do that. Yes, what are these?
The plaintiff want to withdraw the IA civil 1922-815 and permission to.
A motion application for continuance of the previous suit paid by all the years to this honorable court to set aside civil judge so and so to allow opposite to adopt the case on liberty to file and press for. No, what is this application?
My lord,
Why is this matter before me?
my lord, we want to withdraw and to with liberty to file press because subsequent development has happened.
What?
Opposite side has.
Why the matter has come up before me?
Opposite party has withdrawn without liberty and file press suit.
Further taking into account that as the record of it was called, the proceedings was directed to be proceeded with, and there is no date fixed, considering the described for the participation for the 17th. Now what has happened? Now what do you want?
With the petitioner want to withdraw this IA civil 1922-815 and to with liberty to file a fresh suit because subsequent development has happened in this case.
How can I allow this? Suit is pending before the trial court.
Withdraw the case.
What?
This party without any permission.
Whose suit it is?
Title suit 23/2019.
Filed by?
Party.
CR is put up today as the PO is transferred. Seen the honorable court's order dated so and so. Both sides are plaintiffs appeared in person before the court. Heard learning that plaintiff has filed the petition bearing along with copy the withdrawal without in liberty. Okay, suit has been withdrawn. Then?
Yes, want to withdraw this IA civil 1922-815.
Or you want to withdraw this IA?
To file a fresh appeal because subsequent development.
Press what?
Because subsequent development has been.
That has nothing to do. Who is the plaintiff?
Plaintiff we are.
You withdrew the suit.
No, in this court, IA civil, we are the plaintiffs.
No, you are the petitioner.
We are the petitioners.
Yes. Plaintiff is the other side. The suit has been withdrawn.
Without any liberty, so.
Very good. You should be happy. You are the defendant.
But we were to dismiss the subsequent suit because they have filed again same cause of action, order 23, rule 4. We want the subsequent suit to dismiss.
What can I do here?
Now we
To affirm Guwahati High Court order both parties
No,
to appear
now-
before Iman to set aside so and so
now,
and to allow withdraw petition
Now, no,
and to file a fresh suit on the same cause of action? Madam,
my
I
lord,
tell
we
you
have
with
to withdraw.
folded hands, I am not able to understand anything. Yes, Mr. R.B.K. Gogoi, you do help me out. What
My
do you
lord,
understand by
we-
this petition?
now we
Give
have
it to him.
for this suit and
Which one do you want to withdraw?
I see it on like
You want to withdraw this?
815 also. And also
So that particular
with
miscase
liberty
was
to file a
it,
fresh suit.
liberty to file a fresh suit in the.
How do I give it?
Fresh
Process
suit,
cannot-
no, fresh application here.
Here also, how do I give it? There's nothing left.
They have already filed and fresh suit without any permission. So we want the. High
You want
Court-
to challenge that suit.
Yeah.
Then-
You have to challenge in that
No, no,
court.
so, we want to High Court to dismiss the subsequent suit under Order 23, Rule 4,
How?
because they have filed,
So if it is so, why you are not filing an order 7 rule 11 there?
Papers there.
What is all these type of applications?
we want the High Court, they said. that-
Okay, Ms. Swen, so appearing on behalf of the applicant submits that she wants to withdraw this I so accordingly application stands closed on withdrawal. I 815, the learned counsel submits that she wants to withdraw and application stands closed on withdrawal. Okay,
With liberty to. file
liberty for what?
fresh
You
application
go
here.
file press suit, that these are different things.
Here.
Without prejudice to their rights to file any suit if so permissible under law.
We are okay, with the subsequent.
I can't. No, without the withdrawal is permitted without prejudice, their rights to file if any suit is any suit if permitted under law. Good. Yes, Mr. Solia.
My lord,
Yes, what is this? Item number 60 is what? Who is
my
the
lord,
fa-
my lord, I apologize for not being physically able to personally be present. My lord, I'm appearing for Power Grid and Khera, my lord. My lord, this pertains to, my lord, we have come with a limited prayer. My lord, there was a bunch of CRPs which my lord had disposed of by the common judgment and order dated 25/3/2025. My lord, page 62, my lord, para 54. If I may, my lord.
Yes.
My lord, before parting with the records, this court finds it relevant to take note of one submission made by Mr. N.C. Das, the learned senior counsel, for the petitioner that at the time of completion of the delivery of the judgment, in respect of 9 cases, my lord, the installation of the overhead transmission line was not done.
Mr. Counsel, first
my
of all,
lord,
you have to hear wherever you are. Did you file that review application or not?
my lord, we had approached the court to file the review application. However, my lord, there was a slight delay. So the court below had asked us that we had filed an limitation application also, but the court below was of the opinion, my lord, that the matter cannot be registered or taken on board because my lord, order is specific for 30 days, my lord. My lord, their delay is
file it within
primarily
30 days.
attributable,
So go to Supreme
my
Court.
lord,
With this reject your application.
my lord, the primary reason is that the 9
to
cases
Supreme
were
Court.
not the ones of NETC, my lord. Only
I
3
can't
were
help
of.
it. You were given 30 days. Why on earth you could not file the review application?
My lord, the primary reason is, my lord, that when we, in the office, my lord, when we started to take out the documents and see through, we had come to know that the 9 cases are not
Counsel,
attributed.
this was specific. The
My lord.
reason why he has sought for filing the review was specific. Kindly see
My lord.
paragraph 54. Here it
My
says
lord.
that in respect at the time of completion of the delivery in respect of so and so, the installation of overland was not done by Power Grid Corporation, but rather it was done by Northeast Transmission, and as such the imposition upon AI was not proper. So you knew it. Why
lord,
are you making a mistake? You are making this statement. This is on affidavit.
My lord.
Let us have that person concerned. No. Let us have this person. What is this?
My lord, I may be.
No,
My lord, I may be.
let this deponent come before this court. It appears on the face of it that the deponent has made a false statement. So let him appear before this court. Why 340 proceedings?
My lord,
and
the,
yes, sir.
my
340
lord,
proceedings should not be initiated against him.
my lord, I may be allowed to make one submission, my lord.
No,
The
don't make
nine,
any submission. Your only submission you can make is today you are not distinct, so you want to come before the court. Don't make this type of
My-
submission. Don't make false statements before this court, Mr. Counsel.
my lord, I'm not making any false statement, my lord.
Because you see on the date on which I had dictated the order, at the
My lord.
last moment, the learned counsel stated before me
My
that,
lord,
look here, in certain matters, and more particularly giving this specific
my lord,
reason, that in
my lord,
these matters concerned, it was laid by Northeast Power Transmission and not by Power Grid, and as such, we cannot be
my
made
lord,
liable. So I asked them that these are not issues which have been placed, so place it before them by filing a review. So
my lord,
you had the details. And
my
now,
lord,
after having the details, Mr. Counsel, listen,
my lord,
after
my lord,
having the details, now you are saying that you are looking into some papers. My goodness.
my lord, the 9 cases were not of
The matter
NETC,
of
my
the 3 weeks.
lord, only 3. My lord.
Taking into account the council's 6 instructions.
My lord, on 28th, because other matters are there on 28th, my lord, same nature. On
This is
28th,
the matter
Monday.
on 13th of October 2025.
My lord, obliged.
Same order, same order.
My lord, 3 matters, 60, 61,
Matter of
62.
3 weeks. No date fix. This is the matter of the 3 weeks. 60, 61, 62. Don't make false
My lord.
statement before me, before Mr. Counsel. Yes, Mr. Solia, your matter. I was in 82 63. Yes, what is this?
Lordship,
63 is different, no?
The size for including opposite party as respondent.
You want to make a party?
Liquidator.
Why?
The Ascot Bank has liquidated now. Mr. Opposite party has been appointed as the liquidator.
Yes, who is appearing for the other side?
Actually, AU Ahmed appears for the Ascot Bank.
Okay, we issue notice. Issue notice to the issue notice making it returnable on 18th of August 2025, comma. None appears on behalf of the opposite party, on behalf of the respondents on call. Full stop. The extra copy of the writ petition of the instant application be served upon Mr.
I have certain he refused.
Upon
AU Ahmed.
AU Ahmed, the learned counsel who represents the respondents in the writ petition. Isn't it?
Yes, madam. Respondent number 2.
Huh?
Respondent number 2.
Who appeared? The writ petition is against some employee provident fund appellate.
Appellate tribunal and respondent number 2 is the Ascot Bank matter.
And what about one?
One already they have refused. Service is complete.
Okay. Upon the learned counsel representing the respondent number 2 during the course of the day. Full stop. Liberty is given to the respondent number 2 to file objection if so advised.
Well, actually, served him copy of this miscase, but he refused.
Mr. Counsel, extra copy, I have not used copy. Extra copy. Extra copy means there is a meaning out there, no? Yes, Mr. Solia. It is 63. I was saying 27. এইটো to last. It will last. This will be taken. No, this will be taken at 4:45. I'll sit again for Mr. Sam. Yes.
Yes, Lordship, here I have the instruction which I have received from the chief engineer, Lordship. They have communicated, Lordship. They are saying that they are preparing, they're going to prefer an appeal, Lordship. That is the instruction which I have received from the chief engineer in PWD in this matter, Lordship. Because here, since I have received this instruction, Lordship, it has been difficult for me to put this on affidavit. Rather, I am making the submission in front of your Lordship, Lordship.
So they are not inclined to comply.
Lordship. This is the, from the.
Mr. Esoliha, the learned counsel appearing on behalf of the respondent number 1 and 2, who submits that the affidavit could not be filed, taking into account the instructions so provided by the said respondents,
I respond number
to
2.
the effect that the said respondents are contemplating of preferring an appeal against the order dated huh?
24/11/2020.
24/11/2023, and as such are not inclined to comply with the directions passed by this court. First, taking into account that no affidavit has been filed and the counsel appearing on behalf of the respondent number 1 and 2 specifically mentions that the said respondents number 1 and 2 are not inclined to comply with the directions of the court. It appears that the said respondents 1 and 2 apparently the actions of the said respondent numbers 1 and 2 apparently is contemptuous First, be that as it may, this court is of the opinion that before initiating the contempt proceedings, an opportunity should be given to the respondent number 1 and 2 to explain in person why there is no compliance to the judgment and order dated 24/11/2013.
23, 23.
24/11, which order?
24/11/2023.
2023. Passed in WPC number 5305/2022. Full stop. List this matter on 4th of August 2025 at 10:30 a.m. on which date the respondent number 1 and 2 shall be personally present. List the matter again on 28th of July 2025 on which date the respondent number 1 and 2 shall be personally present by video conferencing link to be provided by Mr. A. Solia before the court. Yes, Mr. Sahu. What is this?
I know this is related to the same.
Yes, you have filed affidavit. Why is it not being given?
You want to file some rejoinder?
No, not necessary. Affidavit filed in 2024, we finish it up today itself. That is why I took it as the last item. Now I have almost 1 hour, 5 minutes to dismiss your petition. And then I am yet to sign the earlier order in those two matters. So with this dismissal, that dismissal finished. Okay.
We have stated lawsuit.
Yes. Six.
Regarding 7, payment was done, lordship.
Yeah.
Para 7, lordship, payment was, para 7, 171, lordship, running case.
Report is going to the orthodox application for the period so and so to December has been sanctioned on the money payment was done to the person and the payment was done to the for the period so and so final proceeding has been done and is pending for communication with the police of the implementing activity for the money payment recommended for cancellation due to non-compliance of the we require the submission to the state development and promotion scheme for medium term. There is no sanction letter.
No, lordship, there is no sanction in respect of lordship, the year 2000, to June 2020 to July 2020, December 2020.
No sanction.
Unless and until there is a sanction, they are claiming.
And submission of application alone will not guarantee grant of financial under the scheme. Grant of financial will depend on full conformity to the scheme guidelines which he has paid. So, we dismiss it.
This is a central scheme ministry assured by the Minister of Finance, Industry and Commerce. So the central government should not make any discrimination in the scheme. Once, in some cases, I have one occasion they have issued in the required amendment. Subsequent, they are denying it. Now, based on
No, Mr. Sahu, if you are entitled to subsidy, you see, the law is very clear on this. I think there are many judgments. Hero Honda, there are many judgments to the effect that if you are asking for subsidy, you are to fulfill all the formalities. And if you fail to do so, you are not. I'm not concerned with others happening. There is no question of negative equality out there. If some persons have been given or not. But the fact that when they are stating out here categorically that you don't have the sanction and all, where's the question of you getting any amount?
this scheme, they will make inquiry and if eligible, they will make the inquiry after inquiry.
No, you don't have the sanction.
They will make and they will make arrangement also.
They cannot make the arrangement. You don't have a sanction.
It is their responsibility to make all the sanctions.
No, there's no success business. If you want, you are asking for money. The T-boards, it is not the T-board's business to give it to you unless you fulfill the criteria. No, you don't have the sanction.
I have fulfilled criteria.
Do you have the sanction or not? Then you don't have the sanction. Then how can they give they will
I know
be
issue the sanction letter. And that sanction letter will be sent to the.
Is it your case in your writ petition that they have not provided you the sanction? Then that's not your case where you are asking for the sanction, where you are not seeking a mandamus for the issuance of a sanction, then okay.
Yes, actually, yes, I have compared all the conditions, fulfill all the condition of speed,
No sanction.
and they will issue the sanction letter, they will arrange the payment.
First of all, if a sanction is a prerequisite for grant of aid, then in that regard, if you don't have the sanction, isn't your responsibility for seeking a direction from this court that a sanction should be granted and thereupon to grant him the grant you the subsidy on the basis thereof? Isn't it your requirement? You have not asked for the sanction. If you have not asked for the sanction is a prerequisite, then how do you get it? (14/6/2024) affidavit filed. After 1 year.
Actually, some ties are not properly maintained, they're the misplaced.
Then on 11/6, we have
So,
served the
as
copy to them.
subsequent.
On
petition-
11/6, we have served them the copy.
So,
We admit this petition. Earlier pleading, issue rule, let it come up for hearing in usual course. No, you file it. There's no urgency. He has not got any money, na?
He has got losses from some financial year where there is a sanction losses, he has got losses. Even here, one of the claims in 2018 also losses, that money already he has got.
He has got.
He has got losses, sanction was there.
So you want to recover?
No,
not
sanction
required.
was there. We are going.
recovery is not necessary.
Recovery is
required in
there,
this case
because at the relevant point of sanction was there also.
Are you contemplating recovery? Hello? The heard Mr. D. Sahu, the learned counsel appearing on behalf of the petitioner, and Mr. K. Gowoi, the learned Central Government Standing Counsel, comma. The issues involved would require an in-depth analysis of the law. An in-depth analysis on the aspect as to whether the petitioner would be entitled to the benefits of the scheme issued by the Ministry of Commerce and Industries, Department of Commerce, to the Government of India. This court further takes note of that an affidavit in opposition has been filed, and on merits, a question arises in respect to the interpretation on merits, a question and a detailed deliberation would be required on merits. Accordingly, this court admits the instant petition issue rule. Lists the matter for hearing in the usual course. Come up after 10 years. Usual course is 10 years.